To withdraw, my lord.
11.
Aye.
Okay.
Item 1, my lord. No,
One will come. Wait. Why are you mentioning item 1? Wait.
Item 7, my lord. Very urgent. After the vacation, taken after the vacation. Item 7.
Why?
Informant was not able to come due to some personal.
It will go in December.
My lord.
It will go to December.
After
Adjourn. If you are asking for adjournment, it will go to December. Adjourn. And request December.
item 16.
16. Entry order is there. Achha. Okay, well, that is
Item 25, my lord, taken up next week.
next week not possible, madam. You argue or it will go to December.
Statement of witnesses is 5-day file.
Whatever, I am not in that. Either you argue or it will go to December.
My lord, item 10.
December. Item
25.
My lord, item 101. My lord, it is a compromise matter, but the petitioner could, the informant could not come for which health issues, my lord.
let it come then. We'll see. 53. Yes. Huh?
Next week.
Not next week. Once you ask for adjournment, it will go to December.
CD is not available.
Whatever. Then wait. I'll see. It's required. Don't do it. Yes.
My lord, item 116, my lord.
Yes.
I had sent a register letter that has written answer with incomplete with the addresses. So I pray.
Entry order is there.
No, it is bail. It is after conviction. It is there bail on bail.
Your lordships,
116.
Any
your
mentioning?
lordships, I mean VC, your lordships.
Yes. Yes.
Your
Mr.
lordships, I want to mention one CRLMC number 3352 of 2022. Lordships, the court had specifically directed this matter to be listed on 20th December
Naik. What is the
2020.
urgency?
Lordship, there is a execution of NBW. The husband is a hardcore criminal, your lordships, and the court had directed that no further adjournment will be given. They had
No,
sought for
execution. He is asking for cancellation of NBW.
no, your lordships. NBW, yes. They are
You
asking for,
execute. I have not passed any order. Execute.
but your lordship, there is an interim order. There is an interim order pending till the next date. They took time for 3 days. After that, the matter was never listed. And the court had,
Next week. Yes.
your lordship, may give a date, please.
Yes. He'll give it. Yes.
Item 14, my lord. Can it taken over after vacation?
December.
My lord,
Go to December.
pardon me, Mr. My lord, on behalf of Mr. Chandana Mishra, my lord, due to serious illness, item 102. Monday next week.
102 somebody else mentioned now.
108 somebody.
102 somebody mentioned.
108 months. Due to suffering for dengue.
Right. Personal difficulty. Adjourn. Please.
My,
Yes. Start.
oh, bless you.
Basic over. Yes.
No instruction, my lord.
No instruction. That counsel for the petitioner submit that he has no instruction in this matter. Hence, the matter is dismissed. Yes.
One praying for Passover.
Pass over. Okay.
May I please, Your Lordship? I have prayed for the transfer of the investigation from the General Police to Crime Branch of the Kishanagar PS case number 112 manner.
Why?
Though it was registered in the month of June 2023, there is no substantial investigation.
I don't know. You have only filed the copy of FIR.
Thereafter,
So then
nothing is there.
we don't know. That may not be a ground. See, in 23 June 23, the FIR was registered.
Till that
Mainly
nothing-
because nothing has been done, so I'll transfer it. Then
let them take instruction, my lord. Anything else?
no, see, we
279 304.
304.
see, it's all small offenses.
Their grievance, my lord, it is the case, maybe case of 302, not 304A. Production. So that is, my lord, I will take instruction.
Why unnecessary pending? You seek instruction. See that the I'll record it that you have to do needful to expedite the investigation.
Either the, my lord, the petitioner is in front.
You are the informant, huh?
Yes, my lord.
Petitioner is the informant in the FIR number so and so. The counsel for the petitioner submits that although the
No,
FIR
not my lord.
Not
Which
informant.
capacity has come, my lord, do not
He is
know.
the father of the informant, sorry. Father of
Mr.
father of the informant.
Informant.
Father of the informant. The grievance of the petitioner is, although the FIR was registered on 14/6/2023, but the investigation has not yet been completed. Therefore, he seeks a transfer of the investigation from the local police to crime branch. Local police to the crime branch. Except the copy of FIR, there is no other annexure included with the petition. I am not inclined to entertain this petition. Having said that, the police is directed to do well to see that the investigation in the present case is complete as expediently as possible. With this observation, the petition is disposed of. Yes. Yes. Yes, sir.
Yes, my lord. Here, my lord, the day of passing of the proceeding against the petitioner. And the lordship has returned to page 147. That's
One-
the 47. 147. That's the allegation against the present petitioner.
You are, what is your name? Name is?
Sadasip Rao.
Sadasip. Yes, 147.
Yes, madam.
Yes. What are you asking in this petition?
Question.
Question. Okay. Sadasiva, come
Mad.
to 140. Yes.
Now, lordship may kindly read on the discussion of evidence.
Mm.
The same paragraph.
Yes, 147.
During investigation, has your lordship got it?
I got it.
During investigation, it is found that DIC official named is Srikant Prusti, GM, DIC, Kotak, Sadasip Rao, manager, raw material, and Manoranjan Bishoy, IPO, without raw material section, without any inspection of the MSME of this case and without assessing the annual consumption capacity, recommended them for their empanelment with OSIC for procurement of the coal. This is evident from the record of the DIC and the recommendation letter dated so and so, sent to so and so, so and so, so and so. In this letter, specific recommendation of Srikant Prusti, General Manager, DIC, recommending empanelment of
Civic
the
enterprises and
Com-
Manasco.
concerned MSME observe and empanelment. So this is the allegation.
Yes.
3 persons from the DIC, it's a coal distribution policy your lordship have already dealt with. 3 persons, my lord, in the DIC side, it has been dealt with. One is Srikant Prusti as General Manager, Manoranjan Bishoy, and myself. Now, they were in job during the while the charge sheet was filed. So, government moved, the vigilance moved the government for sanction. Sanction was never accorded in their favor, and the order speaks that there is no conspiracy, the government said. Now, both of them are now out. In spite of that, cognizance was taken against them. They approached this honorable court, and this honorable court quashed.
Out means they are retired. They are retired.
Their prosecution is quashed.
Prosecution of whose prosecution was?
Of Srikant Prusti and Manoranjan Bishoy, the 2 persons. One is,
Okay.
now I am in the middle person. I am at the manager level, general manager, and
If there are 3 accused,
no, there are other accused. I am on DIC side only.
in this,
There are other accused persons from OSIC, your lordship has quashed one, Prabhakar Naik.
my lord, in those cases, my lord, I was the counsel, my lord, I assist your lordship, my lords. Regarding this particular, these are the fake units, my lords, who are provided with this particular subsidized coals to be distributed in open markets. Anyway, my lords, but to cut the matter short, my lord, this is a matter of fresh admission. My lord, my friend Mr. Maharana will argue. I will receive the copies, my lords.
if you notice,
Issue
keep the
notice.
copy. Take it. We'll see. And after 1 week, we'll say, yes, next. Keep this, keep it to you.
Well, I'm giving a copy to my friend.
Yes, my lord, but I'm conscious about the factual aspects. my lords.
Yes.
But I'm not troubling the other points which I have taken. That one.
Let's see if you are covered by this, then
Oh, yes,
end
ma'am.
of the matter.
That's-
Yes. Next.
May it please your lordship.
What extra copy?
The petitioners are seeking quashing of criminal proceeding instituted by the wife of the petitioner.
Wife of the petitioner.
Yes, petitioner number 1. Offense is under section 498A, 322, 506 and
Why
34 of.
passing?
My lord, there is no evidence, I mean to say 161 evidence regarding the offense.
498, this matrimonial dispute, what I'll do is I issue notice, I'll send you to mediation. That's the only thing I do generally. Because it's a matrimonial.
My lord,
Right. Issue notice to opposite party number 2. Returnable within 2 weeks. Since the dispute is arising out of a matrimonial dispute, the petitioner number 1 is the husband of the opposite party number 2, and petitioner number, who is petitioner number 2?
petition number 2 is the god sister of petition number 1. Dharma Bhuvani.
The god sister of, allegedly the god sister of petitioner number 1. She must be saying that you have a relationship or something of that sort. Obviously.
Demand, super demand is concerned or the allegation against them?
And the FIR is registered against the petitioners for alleged offence under section 498A and
498, 323, 506, 34 of IPC read with 4 DP Act.
DPA. I am of the considered opinion that the matter will be settled through mediation. Therefore, the parties are relegated to mediation center without awaiting report. Please the matter. Yes.
Obliged, my lord.
Next. High Court. And where? High Court mediation or where will I send? Where
High
are
Court mediation will be better, my lord.
Where are you?
I am in Cuttack.
You are in Cuttack. Where is that lady?
Lady is in Soro.
So, you bear the expenses.
Yes.
The expenses. The mediation, the travel and staying expenses of opposite party number 2 shall be borne by the petitioner for the purpose of mediation. Accordingly, petitioner is directed to deposit 10,000 rupees with the mediation cell for disbursing the same to the opposite party.
My lord, may quantify the amount.
10,000.
10,000, no? He is, the petitioner
No,
is
no,
a private
no.
plumber, my lord.
5,000. 5. Yes.
Item 6.
May I please? Here, my lord, prayer is for interim release of the vehicle, my lord. Even though there is a direction by the London Session Judge to release the vehicle, but the vehicle has not yet been released as because the FAO is pending. FAO is pending. Constitution proceeding or disposal of FAO is pending. And the order judgment of this honorable court is my case is well covered. And last occasion, my lord was about to pass this order, but
I don't remember.
yes, my lord, but since the order of the Lord SDM was not there, your lordship directed. That's why that it was matter was urgent.
Show me the order, impugn order.
Last page, my lord, of last paragraph of the
Impugn order.
yes, my lord.
No, impugn order to show me.
For the foregoing reasons, I have given my
Reasons, both these have disposal. What is this?
for the foregoing reasons, therefore,
What is
both-
this?
the order of the SDM. That was not in the my file. That's why our matter was urgent.
File it now. Everything you pass on like this, then it should be on record
Yes,
also.
yes.
Then counsel for the petitioner seeks one more opportunity to place on record the relevant documents. You may do so within a week. Please do it after 1 week. You file both these covered judgment also. Both the things. Please the matter after.
Matter may kindly take them next Monday or Tuesday.
He will give you a date. Yes.
Item 8. 7,000.
Yes, sir.
Fine.
Yes, sir.
Is for crossing of the affair against the wife who has been entangled in this.
109.
My lord. And moreover, my lord, the son is a IOCL officer. Only 52% they have sold. Son is a IOCL officer, engineer, and another son is a OFS officer.
Maybe.
That is the
But
and
do
this
you
wife.
have your separate income?
Well,
Do you have separate income? Have you said? That
yes,
you
yes,
have?
the wife is serving as a teacher.
That's the problem. You are not covered by that judgment. Sir.
Lordship,
but
I issue
my
notice.
senior was.
Lordship, I issue notice. I'll copy. I'll give the extra copy to my lord.
Issue notice returnable after 2 weeks. Yes, sir.
Item 9.
Yes. Yes,
Madam,
sir.
the limited prayer before Lordship, the rejection of 457 petition is before Lordship.
Okay.
Cash of rupees 25 lakhs was seized in during course of Millard investigation of a vigilance case.
Hmm.
Admittedly, the petitioner is not an accused. He is the Millard proprietor and director of 2 companies, and as per the balance sheet, cash he can retain the cash. Is the already admitted case. And due to the Millard, the daughter of the petitioner married to the Millard, the father-in-law is accused. Well, Sasura Samudi is accused in a vigilance case. So simultaneously, raid was conducted. So limited prayer by keeping judgment, keeping your Lordship indemnity bond or any property security.
Property
interim,
security.
Yes,
Property
interim relief.
No.
That much only limited.
Bank guarantees.
Bank guarantee not. Property security.
Property ର କିଛି ହବ ନାହିଁ ଆଜ୍ଞା ବହୁତ difficult ହଉଛି very cumbersome
And
procedure.
indemnity can
But he is not an accused.
Yes,
Somebody
I'm-
accused.
But, may suggest me the Your Lordship, this is coming for the first time. my
but
lord.
it can be disputed.
One minute. He has served me a copy, my lords.
I'll put
Already-
it next week, seek instruction.
Correct.
Next week, seek instruction.
Agreed. Agreed.
Many case, what we do is,
The
he
Lordship
gets
judgment.
the, no, he gets the instruction, we dispose it up like.
Their document have annexed the certified copies. Only thing
So
that
therefore, give, I'll put it.
yes, your Lordship, your Lordship.
Issue
My
notice
senior is-
and you seek instruction, either indemnity bond coupled with property.
property.
security.
Your Lordship record that.
Because see, if you say bank guarantee, then
It's
that much
active.
amount is,
You have-
he is a businessman. He is
Business.
a businessman, so his money is stuck.
Any judgment also Honorable Delhi High Court and also this Honorable Court also. Your Lordship has fixed property.
Mr.
security.
Das is
He's
not
very-
opposing, he's trying to find out ways to
Yeah.
get a solution. Next week, huh?
Eh,
Next-
uh,
You just.
Your Lordship simply pass it on that I will get instruction only.
He
With the indemnity bonds
issue
and with
notice-
property,
issue
Lordship
notice,
property.
Das accept notice, and he submits that he would seek instruction in this regard. I'll not say anything, you get it, otherwise I'll, yes.
Oblaze blood.
Item 10.
मैंने कॉपी पाई रहेगा कॉपी पाई
Or this also you can think of, 50% release, 50% of something of that sort. Find out. some way
I'll
out.
explore the feasibility. I
Find out
explore
some way out so that at least. We can-
Indemnity bond and property, both, which in one case, indemnity bond was granted.
See, I'm exploring all
Both,
possibilities.
both. Your Lordship
All
can keep it
possible.
both, indemnity as well as property.
Because you are businessman, you are
Yes, sir.
25 lakhs is stuck.
That is one, that is
So
one.
he is not an accused, his
Samudi.
daughter's
Father-in-law.
father is accused.
बेनामी
गवर्नमेंट तुमको ट्रांसफर करेंगे नहीं तुम कैसे
Yes.
Item 10.
तुम्हारे दे दो ना कॉपीटा कौन तुमको दिया था ना तुम नहीं
Yes, sir.
सर कॉपी था any more I'll request my lord senior
रिजेक्शन ऑफ डिस्चार्ज पिटीशन इज अंडर चैलेंज
Give a copy.
I will give a copy.
I'll put
Let
it
him
up
also take instruction.
after a week,
Man, let him also take instruction. I will give a
Instruction.
copy so that
Yes,
it
yes.
can be decided as
Uh,
per section.
You just supply a copy, then we'll issue notice.
Man,
Returnable.
I will give a copy
After-
today.
when have you given to AG office
Oh.
so I can get
Give another copy, sir.
Yeah, hello. Convert hello.
Now
Yeah.
you give another copy.
Yeah, I will give a copy.
Yes.
Item 12. 12.
नहीं नहीं
11.
copy
Madam, 12, my lord. I'll take around 2 PM, my lord. I'm searching for the case there.
Okay.
Okay.
Pass over. Yes.
13.
May I please?
12 what happened?
12, madam. Pass out the top.
12 pass over at 2 o'clock. Yes. 13.
May I please?
Yes.
My custody since 31,
Sorry.
custody since 31/12/23.
Yeah.
For alleged offence 376 by 511.
Yeah.
Notice of decision.
Yes. You have.
My notice is made subsequent, madam.
Yes.
On my lord, 29/8/2024.
164 read 164.
On 164. 31/10/2023 रात्रि 10
She will be the first witness.
She did not turn up, my lord.
That is good. 3 months. That's what I've said. Yes. Next.
15.
15.
Oblige.
14.
14 what happened?
14.
Urgent. 14 urgent. Yes. 15 sir.
15 I for next week, I'll take instruction what is with regard to the status of the. Let's see, only keep it next week, my lord.
What is the status means?
Whether trial has commenced or not.
Huh?
Trial has commenced or not. Or
Then you repeat your bill.
no, it will be too difficult.
No,
Let
not next week. It's
then I'm
difficult.
placing the I'm then placing the matter, my lord.
Huh?
I'm placing the matter.
Argue the matter.
Yes,
Argue
you'll also
Bail
see
matter, don't ask for adjournment. Yes.
initially case was registered under unknown accused persons, my lord.
Yes.
And
Offense under section?
30234 IPC.
Yes.
Lordship, come to straight away, come to page 28, my lord.
You are in custody since?
I'm in custody since 14/7/2023.
14?
7/2023.
You have
And last of you granted another accused.
And deal with it also the, like this petition and another co-accused.
Which part? After releasing charge sheet you filed on.
Paragraph 5,
The only basis of
Paragraph 5.
the only basis of implication is
Para 5 na?
My lord.
yes.
Milan and Sibo Brutal.
Yes. There is no eyewitness to the occurrence.
Whatever.
Yes, entire case is based on circumstantial evidence. And circumstances is while the main accused Milu Rona and Jitu Rona, they were arrested and in custody of the police. They confessed to have committed the offense.
I will give.
Yes, he also last occasion granted bail to the
Not Milan and Sibo had a different role to play.
He also see page 28, my lord, relevant for page 28.
With the
Jitu, my lord, 3 persons went to the motorcycle. Jitu left the Milan and Sibo, my lord.
she was outside and
outside.
Both of them entered inside, my lord.
You'll also see implications simply basing on the confessional statement of before police. There is no other
material witness.
And leading to discovery at the instance of the main accused, that is Milan Rana.
Petition is accused in connection with the Solangar case. The allegation against the petitioner is under counsel for the petitioner submits that the co-accused Jitu Rana has been enlarged on bail. He seeks parity with Jitu Rana. However, the allegation against the president petitioner and one Milan are different from that of Jitu Rana. In fact, Jitu Rana, Milan, and the president petitioner three went to the house of the deceased. Jitu remained outside. Jitu remained in the outside, whereas Milan and the president petitioner went inside the house of the deceased and allegedly assaulted the deceased, to which the deceased succumbed, caused injury, to which the deceased succumbed. Therefore, the role of attributed to the overtake attributed to the president petitioner is different from that of Jitu Rana. Hence, no parity can be claimed by the petitioner. Having said that, the petitioner can, therefore, I am not inclined to enlarge the petition on bail. However, petitioner is granted liberty to renew the bail plea of the petitioner after the
exemption of material witness.
Trial court shall do well to see that all the material witnesses are preferentially examined over the formal witnesses. With these observations, petition is disposed. Yes. Next.
Item 70.
70. Yes. Twenty. Pass out.
80.
May I please, Lord?
Yes.
The petitioner is in custody since 25th August 2023, my lord.
23?
August 2023.
Yes.
Charge sheet filed on 26/11/2023, my lord.
26/11.
My lord. Under section 498 304B 34 IPC 306 reduced section 4 DP Act, my lord.
Yes.
The petitioner is the husband, my lord. And your lordship can have a
You are the
glance,
husband.
my lord.
Hmm.
Your lordship can have a glance to the statement of a witness, my lord. On the date of occurrence, that is a statement of a Priyanka Parida. I have marked, my lord.
Read out, read out. Read out. Where is your copy?
See what I was saying.
Yes.
May I read one of a statement of a neighbor?
Priyanka Parida.
Another.
Don't do cases so casually.
Sorry, ma'am.
There are 3 persons standing here. You,
Sorry, ma'am.
he and me. How have you got one copy?
Sorry, ma'am.
And then why are you arguing? You say that everything I filed, read it and pass the order. I'll keep on reading. Yes. This is how we waste time unnecessarily.
My lord, I'm just reading the relevant.
Right. Petitioner is in custody since 23/8/2023. The trial was not yet commenced, and since regard being had to the fact that the petitioner was already in custody for more than a year, and the co-accused has been granted bail, I'm inclined to enlarge the petitioner on the bail accordingly. Petitioner.
Okay.
Both are in same footing.
Yes. Yes. Next. 19.
May I please your lordship, here custody 27/11/2023,
27/11/2023. Right.
and though the occurrence took place, my lord, 18/10/2021, my lord, I have been apprehended, my lord, on 27/11/2023. Last entire case, my lord, based upon, my lord, we got a
Recovery. What is the recovery?
recovery from not my possession.
How much? You tell me.
1 quintal, my lord.
1 quintal 82 kg,
2
my lord.
kg has been recovered from a public place near the Surnamani bridge, my lord. And the entire prosecution case, nobody identified the present petitioner. They got a reliable.
This petitioner has been fled away from the spot when the police were reached there. And in last occasion, your lordship was directed to obtain the
Sir, what
instruction of the
case
status of the trial, my lord. And I have obtained the instruction, my
What
lord.
is the status?
Charge has been framed on 3/24, my lord.
6 number of.
Yes, my lord.
List it after immediately after 27/11/2023.
Yes, ma'am.
1 year.
Possession nahi pa hajur koi last
One
occasion
year,
might not
one
opine
year.
that no possession.
I'm telling you, I
Yes.
grant bail after 1 year. 27 for immediately. 28, 29.
ହଜୁର ବେଞ୍ଚ ବଦଳି ଯିବ ଆଉ ସେତେ ହବ
1 year ହେଇଯିବ।
ବେଞ୍ଚ ବଦଳି
Remind me
ଯିବ
on that day.
ଛୁଟି ଆଉ ହବନି ଦୁର୍ଗା ପୂଜା ଛୁଟି ପଡିଯିବ ଛୁଟି ପୂର୍ବରୁ
Remind me on that day. Otherwise, you want a rejection?
no Miller.
Wait.
I play one
I have
thing.
seen 6 witnesses are
Yes,
there.
yes.
1 year, once you complete, I'll grant the bail.
Yes, Miller.
So therefore, I'm saying.
I play Miller.
Huh?
ହଜୁର
Immediately. Let it be 27th itself. No problem.
ହଜୁର ମୋର ଛୋଟିଆ ବ୍ରେକ୍ ଛୁଟି ପୂର୍ବରୁ ଟିକେ ଦୁର୍ଗା ପୂଜା ଛୁଟି ନହେଲେ
1 year ହେଇନଥିବ reject କରିବି।
ବେଞ୍ଚ ବଦଳି ଯିବ ଛୁଟିରେ ବେଞ୍ଚ ବଦଳି ଯିବ ଆସାଇନମେଣ୍ଟ ଚେଞ୍ଜ ହେଇଯିବ
Don't tell all this. Yes. I don't think this will happen. Yes. 20. Remind me on 27th. I'll get it. Yes.
May I please your lordship?
Yes.
The petitioner is in custody since 6/3/2024, lordship.
6/3/24.
6/3/2024,
Yes.
lordship.
Yes.
And
Offense?
offense under section FIR registered under section 302
You
and
have
others.
the
I have
diary,
submitted-
case diary.
Yes, ma'am.
I have submitted the
Charge sheet.
charge sheet also.
Charge sheet 302.
Charge sheet 306, lordship. And
306.
other alleged offences.
Okay.
And
You are the husband.
I am the brother-in-law, lordship. And the date of occurrence, I am not present. I was not present in
Show me.
the
Show me. Your
lordship.
form, I'll get it.
Lordship.
Just see.
one.
Deepak Kumar Parad.
Yes, my lord.
What are the allegations? Deepak Parad.
My lord.
Anything?
My lord, I maybe read one of one section statement, the relevant part of neighbor me. ସେ ମୁଁ ଗତକାଲି ସୋ ସକାଳ ପ୍ରାୟ 7:07 ସମୟରେ ମୋଚିରାମ ବରାଳର ସ୍ତ୍ରୀ ଗୀତା ବରାଳ ତାର ବୋଉ ସୁଚିତ୍ରା ବରାଳ ସ୍ୱାମୀ ପପୁ ବରାଳକୁ ଘଟା 3 ସମୟରେ 10,000 ଟଙ୍କା ଚୋରି କରି ନେଇଯାଉଛୁ ବୋଲି କହି ଅପମାନିତ କରିଥିଲା ଓ ଅଭଦ୍ର ଭାଷାରେ ଗାଳି କରି ମରିଯାଉନୁ ବୋଲି କହିଥିଲେ। ସେଇ ରାଗରେ ସୁଚିତ୍ରା ତା ଶାଶୁ ଘରେ ଥିବା ଚାଉଳରେ ଦିଆଯାଉଥିବା ପୋକମରା ଔଷଧକୁ ସେଲଫସ୍ ଖାଇ ଦେଇଥିଲା। କିଛି ସମୟ ପରେ ସୁଚିତ୍ରାକୁ ତାର ଶାଶୁ ନଣନ୍ଦ ସ୍ୱର୍ଣ୍ଣପ୍ରଭା ଶାସମଲ ମିଶି ଟାଙ୍ଗୀ ମେଡିକାଲ କୁ ନେଇଥିଲେ। ସେଠାରେ ସୁଚିତ୍ରାକୁ
mother-in-law and mother-in-law and sister-in-law.
Okay. What is the role of this Deepak?
ଶାରୀରିକ ମାନସିକ ନିର୍ଯାତନ ଯୋଉ ଟର୍ଚର ପାର୍ଟି otherwise
Is accused in FIR number so the allegation against the allegation in the FIR is told. The petitioner is the brother-in-law of the deceased. The statement of the witnesses recorded under 161 CRPC reveals that the husband of the petitioner alleged the deceased that she has committed theft of rupees 10,000. 10,000. The deceased got annoyed with that and immediately took poison. Took poison. The in-law, the mother-in-law of the deceased and the sister-in-law took her to the hospital. However, she died. However, she died. Insofar as the present petitioner is concerned, he is the brother-in-law of the deceased. There is no specific about attributed to him. He is in custody since 6/3/2024. In view thereof, the petitioner is entitled to bail, accordingly granted bail. Yes, next.
Obliged.
21. Yes.
May I plead your lordship?
Yes, sir.
The petitioner is in custody since 7/6/2023, your lordship.
7/6/23. Okay.
2023. More than 1 year, your lordship.
Yes.
Allegation under section 376(2)(n), 376(2)(i) and 92 of right.
164. Read 164.
and also prior
That I have annexed, your lordship.
that victim is a handicapped lady, my lord, and I am reading out the 164 statement, my lord.
Page 21, your lordship.
ମତେ ଆମ ଗାଁର ମାମୁ ପୁଅ ପ୍ରେମ ନାୟକ ତୋତେ ଭଲ ପାଉଛି ସ୍ତ୍ରୀର ଅଧିକାର ଦେବି ବୋଲି କହି ମତେ ବାହା ହବ କହି ମୋ ସହ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା।
What is the age of this girl?
Age of
22 years, sir.
22, my lord.
What is the deformity?
Deformity is physical handicap.
What kind of
One
Limping, your lordship.
limping?
approximately
Slightly limping.
60%.
But relationship with a promise to marry.
Yes, your
My
lordship.
lord.
He is already there in custody.
ଏବଂ 7 ମାସ ଗର୍ଭ ହେଲାରୁ ମୁଁ ତାକୁ ଯେତେ କହିଲି ବାହା ହେବା ପାଇଁ ସେ
Consensual.
ଥାନା ବୋଲି କହି ଶେଷରେ ମନା କରିଦେଲା। ସେ ମତେ କହିଲେ ଏବଂ ବର୍ତ୍ତମାନ now she is pregnant.
Consensual what? I know. Petition is accused in FIR number 2. Allegation against the petitioner. During the investigation, the statement of the victim, who is 22 years old.
My lord.
Who is 22 years old.
On the date of recording of
Victim was 22 years old.
164.
The date of recording of the case under 164 has CRPC has stated that she was in relationship with the petitioner. The petitioner has promised him to promise her to get married and to get vintage of her, and they kept physical relationship. As a result of which she became pregnant. Subsequent thereto, the petitioner is wriggled out of her his promises. Hence, the FIR was registered. The petitioner is in custody since 7/6/2023. Regarding to the nature of litigation and the period of custody, I am inclined to enlarge the petition on bail, academic is currently bail with all conditions. With all conditions. Yes. Next. 22.
Seems to 14 to 2024 for
14 to
2024
yes.
for the alleged commission of offense under section 419, 417, 493, 313 of the Indian Penal Code.
Yes.
Your Lordship may kindly see the age of the victim informant is 30 years and she is a consenting party to the alleged occurrence.
164 read.
Yes, my Lord. ମୋର
Notice was issued. Notice was issued.
ପୁଲିନ ସାହୁ ମୁଁ ଆଜିକୁ 4 ବର୍ଷ ହେଲା ଜାଣିଅଛି ସେ ମୋ ଭାଇର ଭାଇ ହେବେ ଗତ
ଭାଇର ଭାଇ ହେବେ
ମାଇ ଲର୍ଡ
ଭାଇର ଭାଇ ହେବେ
ମୋ ଭାଉଜର ଭାଇ ହେବେ ସରି ମାଇ ଲର୍ଡ 2021 ମସିହାରେ ମୋର ଦେହ ଖରାପ ଥିଲା ସେତେବେଳେ ସେ ଆମ ଘରକୁ ଆସିଥିଲେ ମୁଁ ମୋ ଦେହ ଦେଖିଥିଲି କଥା ମଧ୍ୟ ହୋଇଥିଲି ତାପରେ ଆମେ ଫୋନରେ କଥା ହେଉଥିଲୁ ସବୁବେଳେ ଯେତେବେଳେ ମୋତେ ବନ୍ଧୁ ହେବା ପାଇଁ ଆସନ୍ତି ସେ ଦୁହେଁ ମୁଁ ଅଛି ବାହା ହୋଇ ତୁ ବା ଅନ୍ୟ ଆଡେ ତୁ ବାହା ହେବାକୁ ଅନ୍ୟ ଆଡେ ଦେଖୁଛୁ ଏତିକି ପାଇବାରେ ମୋର ବହୁତ ବନ୍ଧୁ ଭାଙ୍ଗିଛି ଏମିତି ପାଖାପାଖି ମୋର ବହୁତ ବନ୍ଧୁ ଭାଙ୍ଗିଛି ମୁଁ ମୋର ଘର ଲୋକ ସମସ୍ତେ ପଚାରିଲେ ସେ ଦୁହେଁ ମୁଁ ଘରେ କହିଛି ଘରେ ବାହା ହେବା ପାଇଁ ୟା ଭିତରେ ଆମର ଶାରୀରିକ ସମ୍ପର୍କ ହୁଏ ସେ ସବୁବେଳେ ମତେ କୁହନ୍ତି ମତେ ବାହା ହେବି ସେ କୁହନ୍ତି ମୁଁ ତତେ ବିବାହ କରିବି ବୋଲି କହିଛି ମୋ ସହ ପ୍ରାୟ 4 ବର୍ଷ ହେଲା ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲେ ଗର୍ଭବତୀ ହୋଇ ଜଣାଇବା ପରେ ସେ ମୋଠୁ ମତେ ବାରମ୍ବାର ମେଡିସିନ ଦେବ ପରେ ମେଡିସିନ ଦେବି ଆମେ ଆବର୍ଷଣ ପରେ ମୋର ମେଡିସିନ ଦେଲା ମୋର 1.5 ମାସର ଗର୍ଭ ନଷ୍ଟ ହେଲା ସେ ମତେ କହିବାରୁ ଗର୍ଭ କଥା କହି ଜାଣି ନାହାନ୍ତି ବୋଲି ମୋଠାରୁ 1000 ଟଙ୍କା ନେଲେ ମୁଁ
now these are the against stories. Petitioner is accused in the during the litigation, the statement of the victim under section 164 he has statement. What is the age of this girl?
30 years. 30
during the litigation, the statement of the victim girl who is 30 years, 30 years of age recorded under section 164 CRPC. See, in a statement entirely stated that the petitioner is the brother of her sister-in-law.
Sister-in-law.
Brother of his sister-in-law. They somehow developed relationship. Subsequently, she become pregnant. The petitioner now is wriggled out of his promises to marry her. Therefore, the FIR has been registered. The petitioner is in custody from 14 to 2024. Regarding head to the nature of allegation and so on, so granted bail with all conditions. Yes. Next. 23.
May I please, Your Lordship?
Yes.
Offences under section 20B2C, 102 kilo of contraband article. Jail custody since 8/2/2024. State has to obtain case diary.
Case diary has been received, my lord, and one of a criminal antecedent in the name of this petitioner in other offense, my lord.
Right. Petitioner is accused in FIR number so and so. It is alleged that the recovery of what is recovery?
102 kg.
102 kg of contraband ganja.
My lord, final form 24/7/2024, rejection 16/2/24.
During the petitioner is agreed by the order dated 16/2/2024, whereby his bail plea has been rejected by the trial court. Subsequent thereto, on 24,
my lord,
24/2/2024, the charge sheet is, when the charge sheet was filed, date
charge sheet is 24/07/2024.
24/7/24. The charge sheet in the present case has been filed. In view of the changing circumstances, petitioner is given liberty to renew his bail plea before the court of first instance. I'm not inclined to enlarge the petition on bail of this state. With this liberty, the petitioner is disposed of. Next. 24.
Similar.
Yes, similar, same. Another accused, huh?
Yes, ma'am.
Same. Next. 26. Disposed of.
Fullized.
The
Here.
petition custody since 9/12/2023, my lord.
9/12/2023.
2023.
Yes, sir.
Item number?
Date of occurrence is 29/11/2000. 29/11/2023.
Offense.
Initially, FIR was 363 IPC. Charge sheet was filed under 363, 366, 376, 2N and 6 of the POCSO Act.
Yes.
Yes.
Yes,
CD,
ma'am.
CD is there?
Yes, ma'am.
Yes.
Sir, charge sheeted. Case is charge sheeted and the trial is going on, sir. I am inside the custody since 5/3/2023. And the 160.
Well, the prosecutor is entitled to see the CD. I'll put it 1 week after, okay? 1 week after.
I'm appearing for the informant, what's my fixed date? Because in
Date will be fixed, obviously. 1 week after, date will be fixed. In custody since about a year.
Just directed the victim to be present in person through VC, your lordship. That's why I'm praying for it.
Which item number?
The 29, your lordship.
29.
8/5/2024.
Was there any order to that effect?
8/5/2024. Para 7, your lordship, my peruse.
Para 7. Taken up for filing the informant victim has any objection and yes, shall appear. Yes, yes, Mr. Rahul.
Yes,
there is a direction of the coordinate bench that the victim shall appear.
My lord.
He has appeared now. She has appeared. Where is that victim?
No, abruptly it came today, your lordship. Yes, that's why I'm praying for to fix a date so that I will intimate her and she will appear.
Pursuant to the Mr. Mahapatra and counsel for opposite party victim submits that pursuant to the order dated 8/5/2024, the victim was supposed to appear. However, the matter has suddenly got listed. Hence, the victim could not be present. He is seeking for a fixed date so that the victim can appear on that day. We'll give a date. Yes. Next, 30.
Custody since 29/4/2024.
29/4/2024. Yes.
And 36 kgs of ganja, local person, no antecedent.
No antecedent, I have taken the instruction. Yes, ma'am. Yes,
36 kg. Custody 29/4/2024. No incident and with all normal conditions. Subject to verification of mediation. Yes, granted. Yes. 31. It will go to, I don't know which week, but it will be listed somewhere. Right, on request urgent. 32.
Made.
It will go to December. Yes.
Made.
32.
Made.
Yes, sir.
Made. Initial FIR register 363.
Yes.
Subsequently, the accused was forwarded under section 372N, 363.
Yes, you have diary, sir?
No, my lord, CD is not there.
CD, call for the CD.
Next, 1 week after.
1 week after. Call for CD, 1 week. Yes, next. 33. Yes.
May I please, your lordship. The petitioner is in custody since 26/12/2023.
26/12/2023,
your lordship.
Yes.
During custody, this case has been filed, lost, and he was remanded to this case on 6/1/2024, your lordship.
Okay.
6 January 2024. He was remanded in this present case, my lord.
But he is custody in some other case.
My lord.
In this case, you tell me.
My lord, on 6/1/2024, your lordship.
6/1/24.
Yes, your lordship. And offense under section 420, 294 and 506 of IPC, your lordship. It is alleged that the present petitioner has taken money to sold the land which has not been sold, and the present petitioner took the money prior 13 years of your my lord.
Have you executed this?
Yes, your lordship. Under annexure.
Because last date of hearing, this was the order.
Yes, your lordship.
It says that counsel for the state directed to obtain instruction regarding the genuineness of the sale deed.
My lord.
And the compensation certificate annexure 3 and 4 series.
Yes, your lordship. I have annexed that sale deed and
have you checked it?
incumbency certificate.
Instruction has not come, but the sale date of the year 2000.
No, that's the order of the coordinate bench. You have to comply that.
That instruction has not come. But
I got the certified copy also.
No, that there is the order. He has to say that.
I got the certified copy of the.
Give the certified copy. Pursuant to the order dated 21/6/2024 passed by the coordinate bench, the Lieutenant Counsel for the state could not obtain the instruction regarding the genuineness of this sale deed and encumbrance certificate, to which are annexed with the present petition as annexure 3 series, 3 and 4 series.
3 series and 4.
Mr. Mishra and counsel for the petitioner has today supplied the certified copy of,
Yes, sir, of sale deed.
Entire document.
Of sale deed, your lordship.
Of the sale deed. The state council is directed to verify the genuineness and submit a report. This is the matter after 1 week.
My lord,
It
shorter
made clear
date.
that it made clear that no further adjournments are given in this.
My lord, may I pray one thing, my lord? Your lordship may issue notice to the informant because 2001, that date is of the year 2015.
Meanwhile, notice shall also be served on the opposite party number 2 to the IO of the present case. You served it. No, where is the
Opposite party number?
there is no opposite party here.
My lord,
No, there is no.
it's a government.
Your lordship may give me a party to the informant.
Notice shall also be served on opposite party through informant through the IO of the present case. Please the matter after 1 week, definite date give it. Yes.
My lord, as because it is a tribal by magistrate, my lord, and he is in custody for more than 9 months, I am praying a shorter date may be
I'm
fixed, my
just
lord.
giving after 1 week, leave this week, coming week, and Monday or Tuesday, you give it.
Trial has not been commenced.
It is made clear that no further adjournment.
Trial has not been commenced. Your lordship quashed the charge. Charge once.
I would have gone into it, but there is an order of a coordinate bench. It
Yes,
has to
sir,
be
lordship.
complied.
Yes, sir,
Otherwise, I would have granted the bail.
Yes, sir,
right.
lordship.
And my lord, he may give a
These are the
copy that-
commercial transactions and all.
My lord, only that transaction and some bank account transaction is there, 48 lakhs 95,000.
All are documentary evidences. Why
Yes.
should we
Yes,
be
yes,
in the
ma'am.
custody?
That is documentary evidence.
So because there is an order of the court, therefore I am adjourning. Otherwise, I would have enlarged impediment right now. I am giving opportunity pursuant to the order of court. 1 week after, immediately on Monday. Monday.
Copy it.
Leave this Monday, next Monday.
Deeply obliged, your
Yes.
lordship.
34 minutes, Mr. The petitioner is in custody since 33 2024, Lordship.
Yes.
Under section 420 of IPC manual.
420. Yes. How much you have cheated?
Online cheating of 12 lakhs now.
12 lakhs.
And that my lord, rejection order was on 23/4/24. Then after charge sheet was submitted.
How many informants have come so far? How many people have cheated?
Normally, only this person. He was on online. He was chatting that there is a online chatting for a material, so dress material or for.
No. My lord, I am clear.
From the Google, my lord, there is a.
Are you sure that he has cheated with only one person or many people?
Only one person, my lord. Because he has come forward. That the informant has come forward, and the investigation.
That is the investigation. Has he done?
No, my lord.
With
only,
any other.
Only they have deposited some money in the account of the various account of the other petitioner and his friends. In that account, the informant deposited some of the money. Then some money was also returned to the informant's account. He stated that in that.
How much you have paid back?
Investigation. This reveals that amount 2,10,000 informant deposit to the fraud account manual.
Fraud account.
One fraud account manual.
You have created one.
No, my lord. That
Yes.
was not my favor, my lord. And same day, 2 lakh and some odd deposit, that fraud account deposit some amount to one Tikki Pradhan, my lord. Tikki Pradhan. Kindly have a glance to page 17. Tikki Pradhan statement, my lord.
Who has created that account?
I'm
That is the allegation. You have created that account.
My lord, I am created the account of Tikki Pradhan. That is only
In the name of Tikki Pradhan, you have created the account.
My lord.
That's the problem.
My lord, that is what that they have given a review on Google regarding the hotel and restaurant. They have given a review.
These are the.
That is the.
You will find he might have cheated other people also.
No, my lord.
In this patient.
Stated that not directly linked with me, my lord.
Anyway, renew your bail plea before trial court. After charge sheet has already been filed. Right?
My charge was already framed.
Then you renew because at the investigation stage you had come. That time there was nothing.
I'm not directly linked in the case, my lord. No. Can you have like the forwarding report, my lord? I'm only implicated in this case on the statement of Tikki Pradhan.
Show me the charge sheet. Where is the charge sheet?
Charge sheet is, charge sheet.
What are the, what have you
That the
got
amount,
it?
I mean, reading the relevant portion. The
When the
complainant
charge sheet was filed?
Charge sheet was submitted on my lord, 24/5/24.
Yes.
That the informant, the complainant has given it 21.
2,10,000.
2,10,000 to the account number so and so from my account, and the last payment was 3,39,750 to other account. They wanted more money and give new tax daily.
They wanted means how many? How many?
Present petitioner and other persons are there. Other persons, they are friend. One Tiki Pradhan who is also there. To his account money was also.
Petition is agreed by the order dated 23/4/2024. By when the by which the trial court has rejected the bail application. The bail plea of the petitioner was rejected during the period of investigation. Subsequently, on 24/5/2024, the charge sheet has been filed in this case. Petitioner is in custody since 30th of March 2024. Since subsequently charge sheet has been filed, the petitioner shall approach the trial court by renewing his bail plea. If such bail application is moved, the same shall be considered within 15 days from the date of moving application. Yes, within 15 days.
35.
35 milord. 17-year girl milord. 17-year girl eloped with her boyfriend. That is the allegation. In the meantime, both are married, and the girl, victim girl, has attained majority. And your lordship may kindly glance annexure 3, page 8.
He is 19 years. Boy is 19 years. Custody since?
Custody
4/4/24.
4/4/24. They are married already.
Yes, yes.
Oh, 164.
160. Annexure 3 in the meantime.
The FIR matter 363 and other offenses in the charge sheet matter 366, 376, 2 and POSCO is there.
What are the offenses?
Hello, the offense is 363, 366, 376, 2N, and read with POSCO.
Read 164.
My lord, I would invite my lord to 161 first, my lord.
One minute. Let him 164.
164.
Yes.
ମୁଁ ଘରେ କାହାରି କିଛି ନ କହି ସେ ପିଲା ଭିକକୁ ସାଙ୍ଗରେ ଇନଷ୍ଟାଗ୍ରାମ ରୁ ଚିହ୍ନିଲି, ଆମେ ପରସ୍ପରକୁ ଭଲ ପାଉଥିଲୁ, ତାପରେ ସେ ମତେ କହିଲେ ମୁଁ
of the victim.
17, my lord.
Statement of the victim under who is stated to be 17 years of age at the time of incident was recorded under section 164 CRPC. She stated that she has developed a relationship with the petitioner through Instagram, and she had gone with the petitioner in the motorcycle to Kotak. Thereafter they went to Bhadrak. At Bhadrak, they stayed for 3 days in a conference house. At that point in time, they had physical relationship. Subsequent thereto, both of them came to Kotak and married in a masjid. The petitioner is in custody since 17/2/2024. He is 21 years of age. Regard being head to the period of custody and the nature of acquisition against the petitioner, and the fact that the petitioner and the victim girl has already married as per the statement of the victim, I'm inclined to enlarge the petitioner on bail accordingly granted bail. Yes, next.
Please, obligement.
May I please?
Yes.
My lord, the present petitioner is 30 and the victim is 32, my lord.
Sure.
And it is a consensual relationship.
Double the age.
The victim is 32.
Victim is 32.
32. And
okay, reverse.
Married lady.
Victim is married. And the petitioner is 30.
30.
30.
So you said 13.
No, 30.
Okay.
ସେ ତାର 161 ରେ କହିଲା
custody tell me.
4/4/24
4/4/24
ଆଜ୍ଞା ସେ ତାର ଇଏରେ କହିଲେ 161 ରେ କହିଲା
164 ପଢ।
ଟିକେ ଖାଲି କହିଦଉଛି ମୁଁ ଆଜି ଏତିକିରେ ବୟାନ ଦଉଛି ଯେ ମୋର ସ୍ୱାମୀ ସହିତ ପ୍ରୋବ୍ଲେମ ଥିଲା ତେଣୁ ମୁଁ ଆଉ ଜଣେ ପିଲା ସହିତ ଫୋନରେ କଥା ହେଉଥିଲି ତାର ନାମ ରବୀନ୍ଦ୍ର ସାହୁ ମୋ ସ୍ୱାମୀ ଏକଥା ଜାଣି ମତେ ଗାଳିଗୁଲଜ କଲେ ଓ ବିନା ଦୋଷରେ ସନ୍ଦେହ କଲେ ତେଣୁ ମୁଁ ରାଗି କରି ରବୀନ୍ଦ୍ର ସାହୁ ସହିତ ଗତ 16/11/2023 ରିଖ 10 ଘଣ୍ଟିକା ସମୟରେ ଘରୁ ପଳାଇ ଯାଇଥିଲି 16/11/2023 ଘରୁ ପଳାଇ ଯାଇଥିଲି ଏଫଆଇଆର ହେଲା 4/4/24 ତାପରେ ଯାଇକି ଘରୁ ଯାଇକିରି ଯୋଉମାନଙ୍କ ଘରେ ଯାଇକି ଭଡା ନେଇକି ରହୁଥିଲେ 164 ଅଛି
ସେ ଗୋଟେ ପିଲା ରବୀନ୍ଦ୍ର ସକେଜନ ପିଟିସନ ମୋ ସ୍ୱାମୀଙ୍କ ସହିତ ବସ ରେ କାମ କରୁଥିଲେ ସେ ପିଲାକୁ ମୋ ସ୍ୱାମୀ ବିଭିନ୍ନ କାମରେ ଘରକୁ ପଠାନ୍ତି କଥାବାର୍ତ୍ତା ମୋ ସହିତ ହୁଏ ସେ ମୋ ସହିତ ଜବରଦସ୍ତି ଶାରୀରିକ ସମ୍ପର୍କ ରଖନ୍ତି ଟଙ୍କା ମଧ୍ୟ ନେଇଛି ମତେ ବ୍ଲାକମେଲ କରି
ଚାର୍ଜସିଟ୍ already filed ସ୍ୱାମୀ ସ୍ତ୍ରୀ ହିସାବରେ ରହୁଥିଲେ
Charge sheet has been filed.
31/5/24
The statement of the victim under section 161 CRPC was read over. It reveals that the husband of the victim started doubting regarding the relationship she had with the present petitioner. Therefore, on 16/11/2023, she fled away with the present petitioner
and stayed with him in a rented house.
Stayed with him in a rented house. Subsequently, thereto, on 4/4/2024, this FIR is filed at the instance of the husband of the petitioner, husband of the victim. In the reading of the statement recorded under 164 CRPC also reveals the relation might be a consensual one. Regard being had to the period of custody from 4/4/2024 and the nature of accusation, I am inclined to enlarge the petition on bail according to the grant. Next. 8/30. Yes.
No, offenses 406 and 420. 406 and 420/294 of IPC.
406.
406 and 420/294 of IPC.
Custody?
Custody since
11/4/24.
11/4/24.
And charge sheet 21/5/24. And financial implication is that allegation of 30 lakhs. And petitioner is ready.
He is a company employee.
I'm appearing for the informant. Giving of rupees 5 lakhs. And he is appearing from the informant.
Give it, I will grant bail.
That is what
happened. He is the company manager, present petitioner. Victim is that informant is employee. So here on request that the informant
I'm to give 5 lakhs.
Yes, madam. But the total account was transferred. Though that the allegation is 30 lakhs, but account was to the account
17 lakhs.
It was a transfer that 17 lakhs 65,000.
Yes, ma'am.
So he may deposit some of the amount without
5
any
lakhs
prejudice.
My lord, at this stage, may some
And Wednesday, you give the money. Wednesday, I grant the bail.
Sir, I will hand it over it at the time of release in the.
That may be subject to verification if your lordship may impose that. My lord, he as per the suggestion, he will deposit a draft of rupees 5 lakhs.
I will not make form a part of the order. This is not.
Your lordship may direct
as per the direction of the Honorable Supreme Court.
These are not recovery proceedings. You give it and tell me.
I'll file an affidavit to
your
that
lordship may directed to deposit that money before the lower court below without any prejudice.
Why should the bail court will direct? We are recovery agent or what?
No, madam. That will be deposit before the court below. That is without any prejudice.
Consistent view of the
Because he will take time that whether the draft is genuine or not. That will be deposit before the court below. Trial is going on. If it's money,
my lord,
then it is again complicated.
My lord, this matter might be settled, my lord.
I'll tell you. 1 minute.
My lord.
The court should not be a party to this recovery system.
No, that is correct, my lord. But
okay, but if voluntarily he is paying, taking into consideration the same, I can enlarge him and bail.
Yes,
let him come with the draft if you can.
Yes.
Sir, I will give the draft at the time of release because.
No, the release.
Why I am granting bail.
Sir, subject to be condition imposed that at the time of release, I will hand it over.
That is why I am saying. In fact, while granting bail, one should not have this condition.
Yes.
Because these courts are not here to, as a recovery agents.
The Lordship may keep it to.
These are unfair ways of doing it. But practical thing is money is taken, he has to pay something.
Money is taken, my lord. That is online,
But
that is a bank transfer is there, 17 lakhs.
Jurisprudentially, this is wrong.
If he agree with 7 lakhs, that may be, or 5 lakhs, that may be
Whatever,
deposited before
yes.
the court. That.
What do you say?
Sir, I'm ready to deposit the 5 lakhs.
You get it Tuesday, Wednesday, when? Ask him Tuesday.
Friday, sir.
Next Friday?
Sir, within 7 days. 7 din bhitar.
You give me the date so
Exact
that
date,
on that day I'll release you.
Next week, Monday.
Huh?
Next week, Shukra.
Okay, Friday. Friday, huh? Friday.
Grateful.
Friday, come with that draft. I'll write here, I'll release you.
Yes, sir.
I'll hand it over to him and release you.
41 notice, 41 notice was issued. He denied. For that reason, he was arrested.
41, also, that is observation in police record, sir.
Shall I grant with a week that he will pay?
My lord, with the view that he shall deposit before the land court below and the same in the name of the informant and the same may be disbursed to me. My lord,
Why should he will give it to you?
my lord,
Sir, at the time of release on
at the time of release, the court shall verify whether.
Petitioner is accused. 41 notice was given unnecessary.
And he is also.
Petitioner is accused and so and so. Allegation against the petitioner so and so. At the outset, the learned counsel for the petitioner, on instruction from his client's brother, brother of the client,
brother-in-law,
brother of instruction from the brother of the petitioner, states that he would be making a payment of 5 lakhs to the informant. Mr. Mahapatra, learned counsel for the opposite party informant, submits that if rupees 5 lakhs is granted to begin with, he would have no objection and objection for grant of bail.
At this stage.
Counsel for the state submits that during the investigation, 41 a notice was given to the petitioner, to which he has defied. Therefore, eventually he was taken into custody. The petitioner is in custody since 11/4/2024. Regard being head to the aforementioned,
Charge sheet was filed on 20.
Charge sheet is filed on
21/5/2024.
21/5/2024. Regarding head to the aforementioned, I am inclined to enlarge the petitioner mail, subject to the petitioner, subject to the
verification.
Giving a bank draft of rupees 5 lakhs to the
informant.
Immediately after the.
My lord, prior to release, my lord.
He has to prepare it, na? Prior to release.
My lord, the court shall verify that fact.
Sir, on the date of release. Sir, on the date of release.
High Court and trial court, everybody is there for your as a recovery agent.
Oh, my lord. That is not my condition, my lord.
Immediately after 2 days from the date of release. If I am writing, if any such condition is not complied, then concession of bail shall be recalled.
Sir, date of release
2 days after the release.
Sir, date of release.
And with this condition,
my lord,
the same condition is there on all the matters.
in case of non-compliance,
that is there.
Grateful, my lord.
If he will not comply, then it will be recalled.
Grateful, my lord.
And you can move application before trial court for recall. That I have mentioned.
Grateful, my lord. Grateful.
He will give it and he's taking instruction. I'll just come.
Grateful.
Dispose of. 26, a small child was there. She was married, another father, sister, all were examined. He has not filed the deposition copies. So let him file the deposition copy.
See, all the witnesses have already been examined
No,
by now.
out of 32, 4 have been examined.
See, those witnesses have been examined subsequent to the rejection of bail application.
No, prior to that.
Prior to that, then
Prior
you
to
place
that.
those evidence on record.
Yes, I will file it today itself.
Responsible the petitioner submits that out of 34 witnesses, 4 material witnesses have already been examined. She wants to
32
place-
witnesses, but 32.
She wants to place on record the testimony of those witnesses. Leave the matter after 2 weeks. Yes, next.
40. May I please, Your Lordship?
Yes, sir.
The petitioner is in custody since 13/3/24, 2024. 13/3/2024.
Yes, sir.
The entire allegation is based on the pretext of false promise of marriage. Alleged offense under section.
What is the age of the boy?
Age of the victim is
24.
24.
Victim is 27.
Victim is 28, 27.
164, read.
I am for the informant in this case, Your Lordship.
164, read.
Charge sheet has been submitted, my lord.
When?
Charge sheet has been submitted on dated 15/4/2024.
Read 164.
My lord. That was in seal cover. I opened that.
Read it.
And I relevant portion mo padu. 18/2/23 ମୁଁ ରହୁଥିବା ଭଡ଼ା ଘରେ ଆସି ଜୋର ଜବରଦସ୍ତି ମୋ ସାଙ୍ଗରେ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା। ସେ ବଲାଙ୍ଗୀରରେ ପୋଷ୍ଟେଡ୍ ଅଛି। ଯେତେବେଳେ ବି ଭୁବନେଶ୍ୱର ଆସେ ମତେ ରୁମରେ କିମ୍ବା ହୋଟେଲରେ ଜବରଦସ୍ତି ଶାରୀରିକ ସମ୍ପର୍କ ରଖେ। ମୁଁ ମନା କଲେ ମତେ କୁହେ ଯେ ମତେ ନିଶ୍ଚୟ ବାହା ହେବ ଏବଂ ମତେ ସିନ୍ଦୁର ପିନ୍ଧାଇଲା। ହେଲେ କିଛି ଦିନ ପରେ ମୁଁ ଜାଣିବା ପାଇଲି ଯେ ସେ ଅନ୍ୟ କେଉଁ ଝିଅ ସହିତ ସମ୍ପର୍କ ରଖିଛି। ଏହା ପରେ ମୁଁ ତାକୁ ବାଧ୍ୟ କଲି ସେ
Not married.
No, my lord, what happened?
Are you married or not?
No, my lord, what happened, my lord? The petitioner, my lord, just with 2 minutes, with due permission. The petitioner and the victim girl are preparing for competitive examinations in a library.
I'm asking one question. Are you married?
Sir, what
if
happened?
you are married and promising and keeping relationships, no bail.
My lord, what I am submitting, try to convince me, your lordship. There is a difference between false promise of marriage and breach of the marriage. In the instant case, might have there is certain circumstances which is encountered the petitioners not to marry because prior to lodging of the affair, I have been annexed, my lord, annexed 3. There are certain discussions which I have been just submitted in the WhatsApp chats. Prior lodging to the affair, my lord. There, sir, page 19, one of the chat. Nahole se karo, compromise karo, taku 5 lakhs dio, sabu sort out karo, please. That is the allegations. At the first instance, the petitioner paid 3 lakhs to
yes,
the victim.
Mr. Mishra, what do you want to say?
My lord, your lordship may kindly only.
5 lakh rupees.
No, my lord. Whatever the chart they are producing, I am not aware of it. Your lordship may only kindly permit me to read 2 lines from the affair without disclosing the name of the victim girl.
Yes.
My lord. That is the second page of the affair. Your lordship,
Yes.
whether it amounts to rape or not, that my lord will decide.
Yes.
But the way the life of a girl is spoiled, that your lordship may consider.
Write down. Oh, you tell me. I am not accusing him, of course.
Your lordship may kindly permit me to read only, I may be permitted to read only 1 line in the affair.
Read it.
That is second page. मते से एप्रिल मंथ रे मैरिज करी भी करिचंती सिंदूर पिंधाई की मु तांको घरे कहिवा को कहिलारु टाइम आसु मो दीदी मैरिज करू मु घरे कहिबी आ जबे होटल नियंती these are the things sometimes he loses her sense also.
Lord, what I am
Okay, I am granting bail. Right. Petitioner is accused on so. Okay. The allegation against the petitioner. The during investigation, the statement of the victim under 164 CRPC has been recorded. The victim is 24 years.
So 27
years of age, and whereas the petitioner is 24 years of age. The victim in her statement has stated that they were in a relationship. The petitioner has exploited the relationship by keeping a physical relationship with her with the promise to get married. The counsel for the petitioner has drawn my attention to the WhatsApp chat which is placed as an extra 3 and submits that the victim also demanded 5 lakhs
To sort out the case.
To sort out the case regarding head to the aforementioned and the fact that the petitioner is in custody since 13/3/2024. I'm inclined to enlarge the petition.
My lord, my only one prayer, your lordship may record.
Yes.
This WhatsApp chat, your lordship may kindly record that I am seriously disputing it. My submission
Mr.
only be
Mishra, however, Mr. Mishra seriously disputing regarding the veracity of the WhatsApp chat, which is relied upon by the petitioner. I need not go into the said aspect of the matter. However, I am inclined to enlarge the petition on bail regarding head to the fact that the petitioner is in custody since 13/3/2024 and the nature of acquisition in the
Much
with that condition, my lord, that
with
he shall
all
not
conditions.
contact with
Conditions will be there. Yes.
Much of it.
41.
Obliged.
Yes. Yes, madam.
Permitted to withdraw.
Withdraw. Thank you. Withdraw.
Remove.
Remove. 42.
May I please your lordship?
Yes.
My lord, petitioner in custody since 3rd February 2024.
Yes.
Offense under section 341, 354, 354B, 506, 34 of IPC.
354D and 6.
B.
Yes.
354B.
164. Read 164.
My lord, she is a blind lady.
Blind?
Blind lady. Allegation is that, my lord, when she was coming, at that time, the present petitioner, others people there pressed the chest of the present petitioner.
No, blind lady.
My lord,
What is that?
may petitioner no involved, even if your lordship kindly see.
Now involved or not, she blind girl.
My lord,
and blind girl
no.
and 3/4 of
She
you
has
have
stated, my lord, she has
rabbit
stated,
there.
my lord, she has stated before the investigating agency, not against the present petitioner. Your lordship kindly see 161 statement.
164, my lord.
164 read.
ଯେ ବୁଧବାର ଦିନ ମୁଁ ସନ୍ଧ୍ୟା ସମୟରେ
ତୁଷାର ଶଙ୍କର
ବଜାରକୁ ଯାଇଥିଲି, ମୁହଁରେ କ୍ରିମ ଲଗେଇବାକୁ ବଜାରକୁ କ୍ରିମ ଆଣିବା ପାଇଁ ଯାଇଥିଲି, ଫେରିବା ସମୟରେ ତୁଷାର ସରକାର ଆଉ ଜଣେ ପିଲା ପ୍ରଧାନ ମତେ
petitioner is accused in so and so case. The allegation against the petitioner ठीक है. The statement of the victim girl who is what it is
16 years
16 years age at the time of incident and who is also a blind girl
blind
is recorded under 164 CRP. She intrally has stated that on the what she has stated, read it out.
ତୁଷାର ମତେ ଭିଡା ଭିଡି କଲେ, ତାପରେ ମୁଁ ପିନ୍ଧିଥିବା ଚୁନୀରେ
the petitioner and other
another ପ୍ରଥା
forcefully outrage her modesty, outrage her modesty. Regarding her to the fact that the victim girl is a minor and a blind girl. The blind girl and the petitioner and the other co-accused persons have taken advantage of the minor girl. I am not inclined to enlarge the petition on bail. However, the liberty is granted to the petitioner to renew the bail plea after the examination of the victim. Yes. Next.
43, my lord. The petitioner is in custody, my lord, since 28/3/24, my lord.
24.
My lord.
Yes.
Offense under section 21B of the NDPS Act, my lord.
Recovery?
Recovery of
114 gram brown sugar.
Charge sheet in the meantime submitted.
Final PR submitted.
Final
PR submitted. Antecedents?
No.
No answer. No antecedent, but man, brown sugar.
Brown sugar.
That is much more dangerous than my lord.
I know. In Orissa also this thing is started happening. That's the pain. What to do? 20/3/2024. Appear before the police station.
Yes, ma'am.
For 6 months. Every Sunday. Appear local or outside?
Local person.
Local person.
Grant bail. He shall appear before the IIC. Which police station?
That is
Old Town. PS Lingaraj.
PS Lingaraj. on every Sunday at 10:30 to 12 p.m. For 6 months. For 6 months. Regard being head to the contraband quantity of contraband seized. What is 187 gram?
114 gram. 114 gram.
114 gram and custody from 28/3/24. Yes.
With the condition that he shall not involve in the similar type of
Oh,
offense.
those conditions will be there. Subject to verification of antecedent and all.
My lord, petition is
44.
custody since 24/4/2024.
24/4.
2024.
Custody 25, my lord, not 24. 25/4/24.
24, huh?
My lord, 25/4/24.
24, yes.
Recovery is 82 gram brown sugar.
The charge has already been framed.
Same position. Same kar do. 6 months.
Charge has already been framed. Charge has already been framed.
Your police station is Khuntuni.
Khuntuni
police.
Khuntuni police. Yes. The brown sugar has become a menace now.
Yes,
in Orissa. We have to discourage granting bail. I'm seeing the Ganja is all right, but
Mind you, brown
brown
sugar is much more than the
floating in the market. If less than commercial quantity, then you have to grant bail. And all these people are young.
Young peoples, they perhaps taking that for their own consumption.
They are consuming themselves.
For own consumption.
For own consumption. age भी लिख दिए पिलर में बीटा ग्रे देख लियो एज के पे ठीक है regarding that to the period of custody the age of the yes
Lordship
खबर लिख दो yes 45
Lordship judicial custody on 21/12/2021
हाँ
accused in judicial custody 21/12/2021
21/12/24
21 2021 Lordship
okay. Yes
allegation under section IPC 302 and 320
you have the
yes that is there
yes. What are the allegations against
302 that the petitioner he was that is a community center that the petitioner this is was present and petitioner was present. He has used some slang language that the present petitioner. Deceased told him that it is a community center, you don't use such type of word. So what he has done, he has bring a knife and assaulted the present petitioner. Assaulted the
eyewitness must be there.
Eyewitnesses are there, my lord. Out of 35 witnesses, 14 witnesses have been examined and 12
yes,
witnesses supported.
Madam, what do you want to say? See, out of 35 witnesses, 14 witnesses have already been examined.
Yes, Lordship. Actually, petitioner is a poor family, and now the about 5 months above, I have engaged this case. Lordship, I have filed CRPC 311 for recall petition for eyewitness. But sir, the honorable court rejected that petition. But sir, how can we know that, sir? Because this is the in the FIR, Digit brothers say that fight to each other. But how we know that, sir? Fight the person is direct attack to the person.
That is why the trial. Only to know this how we have done.
Sir, but without Lordship, Lordship.
So your application under 311 is rejected. Is not a
rejected, but sir, say जेहेतु sir already government advocate ये case रे गरीब तो sir को private advocate engage कर न थे Lordship, but सेही case रे सेही government advocate both defense and prosecution कर थे मु ये 4-5 मास रो engage हेली जेहेतु मोर जोटा duty थे
आपण पढ़िया को चाहूँ कि further
sir मु ये liberty चाहूँ से pray करती Lordship की तंगु
she is not ready. I am simply urging you get ready. All these things will not matter. You tell me on merits. Okay. I think you have not read the file. I am just accommodating you for preparation after 2 weeks. After 2 weeks. She is not prepared himself.
You will also make it
40?
46.
46. Okay. Yes. 46. Yes, sir, 46. I will not pass over. Today it's very
My lord,
difficult.
46,
About how many
20 B
matters?
2IC, 200 kg ganja.
70 matters are there, so not possible for a pass. 200 kilo.
200 kg. My lord, noting is that surrender certificate has not yet been filed.
The petitioner was enlarged on interim bail by the order dated.
Perhaps it is 28/5/24.
Enlarged on interim bail by the order dated 28/5/2024. The petitioner has not filed the surrender certificate.
And it also, my lord, extended on 11/7/24. That was extended.
Not filed surrender certificate as yet, despite the fact that it was further the interim bail was further extended. Non-APS for the petitioner. In view thereof, the regular bail application moved by the petitioner is dismissed. Dismissed. That's
And my lord, trial court may be directed to issue.
trial court shall take necessary steps to issue process for ensuring the presence of the accused. Yes, next.
47.
Dismiss. 47.
May I please, Lord? My
Yes.
lord, this is application under section, my lord, 147, 148, 64.
Tell me what are the offenses. Don't you?
And 302, my lord.
302. You are in
Last-
custody since?
Custody since, my lord,
81/24.
81/24, my lord.
81/24.
Initial, my lord, FIR was registered under section 364A, 307/506. Then, my lord, the
302.
charge sheet was submitted that it was turned to 302.
When charge sheet submitted?
Charge sheet was submitted on 3/5/24.
3/5/24. Right out.
Rejection order is
Petitioner is agreed by the order dated 18/4/2024, whereby his bail plea has been rejected. The FIR was initially registered for alleged offence under section 364A, 323, 307, 325, 294, 506, and 34 IPC. After investigation, charge sheet has been filed on
My charge sheet filed on 3/5/24.
3/5/24.
And it was turned to 302 and other
For
offenses.
the offence of 302 is now found to be alleged in the charge sheet. And since during the investigation the bail plea was rejected, the petitioner is granted liberty to renew the bail plea before the trial, before the court of first instance in the changing circumstances. Accordingly, the present petition is dismissed. Yes, next.
48.
Yes, 48.
Please, madam.
Yes,
The
sir.
petitioner has been charged sheeted for the offences 450, 394, 307, 354B, 427, 516, 20.
Yes, custody
Custody since 3/10/2023.
3/10/23.
2023.
Okay. Yes.
Well, actually, CD is not available.
Hmm.
But he has 10 numbers of criminal antecedent.
Get the CD then.
And
He
out
has
of
also filed the comprehensive affidavit.
And the
Out of 10 cases, he has been acquitted in 3 cases.
submits that the petitioner has 10 number of antecedents. Then counsel for the petitioner is directed to file an affidavit giving details of the cases pending against the petitioner and the status of those cases. At least the matter after 2 weeks.
After
Meanwhile, CD of the case may be called for.
Madam, pardon, after 1.
Give it. Yes.
49.
49.
4 weeks कहने नहीं 1 week.
नहीं 2 weeks.
1 week.
नहीं आसिफ सोनपुर later.
आनी परिवीन बेकार ऐड जना हो पाई जाओ. Yes.
May please, Lord, my lord. The petition is in custody, my lord, 6/2/2024, my lord.
6/2/2024,
2024, my lord.
24. Okay.
Offense under section, my lord.
Or notice to.
As per noting, my lord, the recusals of file. Kindly see the
Notice, sir.
Could not be made due to late filing for acceptance.
The notice on opposite party number 2 could not be served due to the late filing of the recusers on behalf of the petitioner. The recusers already filed may be utilized for the purpose of serving the opposite party number 2, leaves the matter after 3 weeks. Next. 4 weeks. 4 weeks.
My lord, 376(2)(n), 6 POCSO, custody since 17/11/23.
17/11/23. Yes.
Charge sheet filed on 29/12/23.
29.
I have filed the statement of the victim.
Yes.
Annexure 3, page 16, ma'am.
Yes.
ଦି ଜଣକୁ ଭଲ ପାଉଥିଲେ they fled away from to Gujarat, stayed there for 10 months.
Yes, sir. Same. Girl is
17.
17. This boy is
27.
27.
27.
He married this
No, not married. Both will get married after release of the petitioner.
Just see 164. Right now, petitioner is accused in connection with the affairs also, allegations also. During the investigation, the statement of the victim under 164 CRPC was recorded. C inter alia stated that the petitioner C has been in relationship with the petitioner. Since the family member did not agree to the alliance, C fled away with the petitioner and they stayed happily together, being wife and husband. The victim girl was subsequently rescued and the FIR was registered.
Initially FIR registered.
Subsequently rescued. And the charge sheet has been filed on
29/12/23.
Petitioner is in custody since
17/11/2023.
The Land Counsel for the petitioner submits that since the petitioner is in relationship with the victim girl, she is intending, the petitioner is intending to marry her. However, the family members are not agreeable to the alliance. Regard being head to the aforementioned, the period of custody, I am inclined to enlarge the petitioner on bail. Granted bail.
Okay.
51. Password, I don't know. It's possible or not. Anyway, password. 62. Because see, so many cases, 70 matters.
I pray on behalf of Mr. Sahu for adjournment.
Adjournment. Okay. Adjourn. On request adjourn. And go to December, huh? Be ready with that. Yes.
Petitioner is in custody, my lord, February 12, 2024, my lord.
15?
February 12, 2024.
15. Actually, he has come 1 month. Passover may not be possible today, so therefore.
The case, my lord.
52, na?
51 again. The case, my lord, all the offences are tribal by state. The offences are 294, 292.
Custody since?
My lord, I am custody, my lord, 10/4/2024.
Yes.
And the offences are, my lord, 292A, 294, 354, 354A, 385, 506, 509, my lord. Yes, charged is the file, my lord. And the case, my lord, only allegation is that.
Yes.
Allegation is that, my lord, the present petitioner, my lord, has my lord, taken some photographs and tried to, my lord, make it viral, but no viral has been there and nothing is there. But
charge sheet filed.
Again, charge sheet filed.
That when? What have you got? Has he taken nude photograph of
No,
girl? Because you have invoked Information Technology Act 66. 60.
Smart mobile phones.
The
above mentioned articles, documents seized on production by the accused. Some absence photographs kept on.
Obscene photographs.
Because it has been sent, my lord, it must have to come out in that the particular my lord has been taken.
No. But the problem is not that. Problem is your age.
Yeah,
you are 45 years. This is a child.
A child, 20 years.
Whatever, 45 years. You are married man and you are doing all this thing, taking photographs and all. Right.
Stringent
Petitioner
condition.
is agreed by the order dated. Where is that order?
My lord, that is.
Order dated 26/4/2024,
Yes,
whereby his bail plea has been rejected. Subsequent thereto, charge sheet was filed on 19/5/2024. Since during the investigation period, the petitioner had moved up bail application. Subsequent thereto, the charge sheet has been filed on 19/5/2024. In the changing circumstances, petitioner should approach the court of first instance renewing the bail plea. with this liberty, the petition is disposed of. Yes.
I may add one line because of the fact that in the meantime,
Within 15 days of moving.
without being influenced by the previous
Without
order,
being influenced by the
previous
earlier,
order of rejection.
earlier observation made by the trial court while rejecting the bail. Yes. 53.
My lord, petitioner is in custody.
CD. Call for CD. Yes. Next. 54.
1 week after.
Yes, sir.
54, my lord, alleged offense under section POSCO Act, my lords.
6 kg and another motorcycle 30 kg, my lord. 4%.
You are riding the bike.
Yes. The all petitioner 4% are before your lordship in this.
All
case.
the 4.
All 4.
What is
In
it?
your
Antecedent?
no antecedent.
Subject to
Very
incident and you 4 of you have to appear before the IIC for 6 months. 6
Yes.
months, let them appear. I know. How many applications?
1 application for 4 petitioners.
The petitioners are accusing files also. Allegations of the petitioners also. These the 4 petitioners were riding
2 motorcycles.
They were riding 2 motorcycles, and 2 of them were riding 2 motorcycles, and the remaining 2 were the pillion riders. Pillion riders. There was a recovery of 56 kg of contraband ganja. In 1 motorcycle, 30 kilo ganja was being carried by 2 of them, and in the other motorcycle, 26 kilo of ganja being carried out by them. The petitioners are in custody since 4/3/2024. Regard being had to the nature of acquisition and 1 kg of contraband period of custody. I am inclined to enlarge the petition on bail, subject to verification of antecedents and 6 months. 6 months, yes.
Hopeless.
Granted, yes. 57.
I may plead your lordship. The petitioner is in custody since 28/3/24 under section 453.
28?
My lord.
28/3/24.
28/3/24.
Okay.
Under section 376(1), 6 POSCO Act, 450 and 506 of IPC.
Yes, you are
After
26.
20 days, FIR was large. Both after 20 days.
20 days. Yes. 164. Read 164.
One PM ସମୟରେ ମୁଁ ଆମ ଘର ଏକୁଟିଆ ଥିବା ବେଳେ ମୋ ମଝିଆ ଭଉଣୀର ଝିଅର ଗୟା ଆମ ଘରକୁ ଆସି ମୋତେ ପାଣି ମାଗିଲା। ମୁଁ ପାଣି ଆଣିବା ସମୟରେ ସେ ଘର ବନ୍ଦ କଲା।
Read little louder. I have to hear it. Yes.
କବାଟ ବନ୍ଦ କରି ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା। ଏକଥା କାହା ଆଗରେ କହିଲେ?
They were not in relationship. They were not in relationship. They were not in relationship. What is the age of the girl?
17.
17.
Then let her be examined. The petition is accused in FIR number also. Statement of the victim under section 164 CRPC was recorded, and he stated in a statement that the petitioner is the brother-in-law of her younger sister and the middle sister. On the date of the incident, when he entered into the house, he forcibly committed sexual act with her. The petitioner is 26 years of age. Regarding that, to the nature of accusation made against the victim, I am not inclined to enlarge the petition on bail. Over liberty granted immediately after the victim of the case is examined. And the trial court is directed to do well to see that the victim is examined by giving preference over all other witnesses. With this observation, the petition is disposed of. Next. Yes. 58.
Where, please?
If it, let's say, 302 CD is required.
CD call.
City once called for blood.
That is 17.5 it was called for.
He has
बहुत
not,
दिन आगुरु
he
call
has
for it.
not got the
Obviously,
submit that
mana
he has
kuni
not
consider that.
received the CD of the case and adjourned 2 weeks. Yes.
59.
May pre-dealership Miller, 35 kg, young boy Miller, 24 years, having no past criminal antecedent Miller, and 2 circumstances in the Miller, 2 persons in a car Miller, 2 bags were recovered.
Ganja. Custody since
30/4/2024.
30/4/2024. Granted, with the same condition. Antecedent verification of antecedent 6 months, 2 weeks. Yes.
60.
60.
Item 60 and item 76.
Custody. Custody. Recovery. 34.
Item 60 and item 76 arises out of same affair.
Yes.
In item 60, my lord, 2 ladies are there. And item 76, the other male members of the family, they have been implicated.
Yes. 302. Yes. What are the allegations against the ladies?
But with regard to that black magic thing, my lord, they suspected the deceased.
Custody since custody?
The ladies were in custody in BLFL number 4823. They are inside custody since 11/3/2024.
11/6 na 3.
11/3.
Yes. Do you have CD?
Yes.
Yes.
Young ladies, my lord, they have their own
Yes.
children. Children are not also properly taken
What
care
are
of.
the allegations against these ladies?
ଏମାନଙ୍କ ନାଁରେ allegation ଯେ ଏମାନେ ଯୋଉମାନେ ମାରିଲେ ତାଙ୍କ ସାଙ୍ଗରେ ଥିଲେ।
ସାଙ୍ଗରେ ଥିଲା ମାନେ ଟାଣିକି ନେଲେ ସେମାନେ ବି ଲେଖିଛନ୍ତି।
ଏମାନେ ଟାଣିଲେ ସେମାନେ ମାରିଲେ।
Read that part.
ମାରିବାଟା କେହି ଦେଖିନାହାନ୍ତି ଆଜ୍ଞା। ମାରିବାରେ ଆଇ ୱିଟନେସ୍ କେହି ନାହାନ୍ତି।
Have you gone through?
Yes,
I'll pass it up.
no pass over. ମୁଁ ତାକୁ ଗୁଣି କରି ମାରିଛି ବୋଲି କହିଲା, ତଥାପି ଆମେ ତୁନେଇରେ ଗଲୁ। କିଛି ଦିନ ପରେ ମୋର ଶ୍ୱଶୁର ମାତୃଶାନ୍ତା ମଧ୍ୟ ମରିଗଲେ। ତାକୁ ମଧ୍ୟ ଗୁରୁବାରୀ ଆସି ତାକୁ ଗୁଣି କରି ମାରିଛି ବୋଲି କହିଲା। ସମସ୍ତେ ତୁମ ପରିବାରକୁ ଗୁଣି କରି ମାରିଲେ ମୁଁ ଶାନ୍ତି ହେବି ବୋଲି କହିଲା। ଆମେ ତାକୁ ଭୟ କରୁଥିଲୁ। ଗତ କିଛି ଦିନ ହେବ ମୋର ସ୍ୱାମୀ ସାରଥୀ ଶାନ୍ତା ହଠାତ୍ ଅସୁସ୍ଥ ହୋଇଗଲା। ଆମେ ବହୁତ ଭୟ ହୋଇଗଲୁ ଯେ ତାଙ୍କୁ ମଧ୍ୟ ଗୁରୁବାରୀ ମାରିଦେବ। ତେଣୁ ଆମେ ପରିବାର ଲୋକ ସ୍ଥିର କଲୁ।
Guruvari deceased. Sarathi is one of the petitioner in item number 76.
ଆମେ ସମସ୍ତେ
The husband of
ଏଟା ହଉଛି
Kajali.
କଳିକି ଶାନ୍ତାର
Kajali.
କଳିକି।
Padma.
Yes, all they have stated the same things
What?
that we have ଆମେ ଗୁରୁବାରୀକୁ ମାରିଦେବୁ। ତେଣୁ ଗତ 7/3/2024 ରାତିରେ ଝରିଗାଁରୁ ତାଙ୍କ ଘରକୁ ଫେରିବା ବାଟରେ ତାଙ୍କ ଘର ପାଖରୁ ମୁଁ ଓ ମୋର ସ୍ୱାମୀ ସାରଥୀ ଶାନ୍ତା ଓ ମୋର ଯା ଚମ୍ପା, for that only all these three are entering, ଶାନ୍ତା ଓ ତାଙ୍କ ସ୍ୱାମୀ ମୁଗୁରି ଶାନ୍ତା ମିଶି ରବିବାରୀ ଶାନ୍ତାକୁ ବାଟରୁ ଟାଣି ଟାଣି ଆଣି ଆମ ଘରକୁ ଆଣିଲୁ। ଆମ ଘର ବାହାରେ ମୋର ମଇନା ଭାଇ ପାଇକ ଶାନ୍ତା ଓ ମୋର ଦିଅର ମୁଗୁରି ଶାନ୍ତା ଶୋଇଥିଲେ। ସେମାନେ 2 ଜଣ ନିଷ୍ପତ୍ତି କଲେ ଯେ ଗୁରୁବାରୀକୁ ମାରିଦେବୁ ବୋଲି ଓ ତାକୁ ରାତିରେ ଜବରଦସ୍ତି ଉଠାଇ ନେଇ ବାହାରକୁ ନେଲେ। ସେ ବଞ୍ଚିଥିଲେ ଆମ ଘର ପରିବାର ପ୍ରତି ଗୁଣି କରି ମାରିଦେବୁ ବୋଲି ସନ୍ଦେହ କରି ତାକୁ ମାରିଦେଇ ସେମାନେ 2 ଜଣ ମିଶି ବୋହି ତାକୁ ଗୁରୁବାରୀ ଶାନ୍ତାର ଜମି ପାଖ କାନ ଝରନ ନାଳ ପାଖରେ ପୋତିଦେଲେ।
ମାନେ ମୁଗୁରି ଶାନ୍ତା ପାଇକ ଶାନ୍ତା 2 ଜଣ ମାରିଛନ୍ତି।
This is Kajali Santa.
That's against he is an accused.
Sarathi said.
Yes. Confession.
Yes, confession.
What else you have?
Eyewitness के नाहंती occurrence रो बा।
It is in night they have all they have done and
Are you on the basis of confessional statement of accused? Can you hold them like this? What else you have except confessional statement?
नहीं आगु
Then after that police went and as per their statement police gone and recovered dig the
Who is the witness to the recovery?
Yes, that is there. The
ये
villagers were there. ମୋର ନାମ ଦରମା ଶାନ୍ତା 35 years। ରିଖରେ ମକଦ୍ଦମାର ସମ୍ବନ୍ଧରେ ମୋ ବୟାନ ନେଇକି ଯେ ଆମ ଘରେ
Recovery evidence 27 recovery. I put it next week. We prepare it. 27 recovery. You tell me. Except the confessional statement is neither here nor there. Unless the recovery witness supports
But may I suggest one thing? Lordship may consider for petitioners in DLAPL number.
No, I'll consider all are entitled to bail according to me so far. If he can't satisfy me, I'll put it next week. All of you are entitled to bail. The same role. Same role. Even the Sarthi has the same role.
ନାଇଁ ମୁଗୁରି ଆଉ ପିଟିସନ ନମ୍ବର 2 ଆଉ 3 in BLAPL number 4994
ନାଇଁ 4823
4823 relates to only the lady member.
That's
two
what.
lady member.
That's what.
Yes.
So next week, read it and tell me what are the evidence. Next week, keep it next week. Yes.
61.
And you just tell me, except the confessional statement of co-accused person,
seizure
witness, what are the evidence you are relying
only
on?
seizure witness are there.
Whatever you read it, tell me, so that I'll examine that part. Yes,
Lordship.
Yes. Next.
61.
60 and 76 both.
60, 76, next week. Friday. Yes. Yes.
61.
Case diary is there.
Yes.
Offense.
Offense, Lordship. 376(3) there.
376(3). Notice was issued.
Yes, notice.
Notice was not issued. Issue notice to the informant oblique victim. Is it POXO is there also there?
Yes, sir.
Informant as well as the victim through the IAH. Please the matter. Yes, next.
62.
After 4 weeks. Non-appeal for
Your Lordship, this petitioner is alleged 62 Miller.
Yes, 62. Yes.
Yes, Miller. The accused petitioner is in custody since 9/12/2023.
9/12/23.
Miller.
Yes.
For
6 and 17 of POSCO is there.
Only 6 Miller. Miller, I want to pray your Lordship to repair the 164 statement of the victim, Miller, where he has not stated anything regarding any sexual offense with the accused petitioner, Miller. Only she has stated.
Read 164.
Miller.
Because
supplied to the State Council, at least the matter after 2 weeks. Next.
64.
Yes.
May I please, Lordship?
Yes, sir.
In this case, Lordship, petitioner has been charged under section 306, 304B and 498A.
Yes.
Of IPC.
You are the husband.
Madam.
Yes.
And
custody since. Custody since
1/4/2024, madam.
1/4/2024. Okay.
And as far as 161 statements are concerned, Lordship, there is no specific allegation of any torture or demand of dowry. There is omnibus allegation, Lordship. And the
died. How she died?
She committed suicide, my lord. 306, Lordship.
Yes.
And your Lordship.
1 minute. Yes.
Suicidal hanging is there.
How she bolted the door from inside or anything of that sort?
That I am reading, Lordship. That 161 statement, Lordship.
Any eyewitness?
Eyewitness in order but by breaking the door only.
Breaking the door,
yes,
they
yes.
read it.
Lordship, ମୌଚି ମୃତାନୀ ମହାପାତ୍ର ଆଜି ତା 29 ତାରିଖ ଆପଣଙ୍କ ନିକଟରେ ମୋର ବୟାନ ଦେଉଛି। ମୋର ଭଉଣୀ ଶ୍ରଦ୍ଧାଞ୍ଜଳି ମହାପାତ୍ର ଏତେ ଜଗମୋହନ ଥାନା ଖଣ୍ଡଗିରିରେ ସ୍ଥିତ ବିଷ୍ଣୁପ୍ରିୟା ମହାପାତ୍ର ତୃତୀୟ ଗୌରବ ପ୍ରଦାନ ସଭାଗଲ ବିଭାଗର ପରେ ଜ୍ୱାଇଁ ଗୁରୁ ଶ୍ରଦ୍ଧାଞ୍ଜଳିକୁ ଯୌତୁକ ବାବଦକୁ ଅନେକ ସମୟରେ ନିର୍ଯାତନା ଦିଆଛନ୍ତି। ସ୍ୱାମୀ ଗୁନୁ ଏକ ସ୍କୁଲରେ ଟିଚର ଚାକିରି କରନ୍ତି। ବାହାଘର ପରେ ଶ୍ରଦ୍ଧାଞ୍ଜଳି ତାଙ୍କ ଘର ଲୋକଙ୍କ କଥାରେ ଚାଲେ, ଯାହାକି ଗୁରୁଙ୍କୁ ପସନ୍ଦ ନୁହେଁ। ଏଣୁ ବହୁ ସମୟରେ ତାଙ୍କ ଦୁଇ ଜଣଙ୍କ ମଧ୍ୟରେ ଝଗଡ଼ା ହୋଇଥାଏ। ଏହା ଛଡ଼ା ଗୁରୁ ଅନେକ ଫାଇନାନ୍ସିଆଲ କମ୍ପାନୀରୁ ଟଙ୍କା ଲୋକଙ୍କ ଠାରୁ ପଇସା ଧାର ଉଧାର କରିଥିଲେ, କିନ୍ତୁ ଏହାକୁ ଠିକ ସମୟରେ ଭରି ପାରିନଥିଲେ। ଲୋକ ପଇସା ନ ଭରିବାରୁ ଶ୍ରଦ୍ଧାଞ୍ଜଳିଙ୍କ ମୋବାଇଲକୁ ଲୋକେ ଫାଇନାନ୍ସ କମ୍ପାନୀରୁ ଫୋନ କଲ୍ ଆସିଥାଏ। ଏଣୁ ଶ୍ରଦ୍ଧାଞ୍ଜଳି ଏଥିରେ ବିରୋଧ କରିବାରୁ ଗୁନୁ ତାକୁ ଏଇ ଟଙ୍କା ତାଙ୍କ ବାପ ଘରୁ ଆଣିବାକୁ କହିଥାନ୍ତି। ଶ୍ରଦ୍ଧାଞ୍ଜଳିର ମୃତ୍ୟୁ ପୂର୍ବରୁ ମଧ୍ୟ ରୁନୁ ତାଙ୍କ ଭିତରେ ଝଗଡ଼ା ହୋଇଥିଲା। ଶ୍ରଦ୍ଧାଞ୍ଜଳିଙ୍କର ସ୍ୱାମୀ ତାଙ୍କୁ ଶାରୀରିକ ମାନସିକ ନିର୍ଯାତନା ଦିଅନ୍ତି, ଯାହା ଫଳରେ ଶ୍ରଦ୍ଧାଞ୍ଜଳିଙ୍କୁ ଆଜି ମୃତ୍ୟୁ ହୋଇଛି।
Where they bolted the door, or he was rescued very bad.
Let's say that is there. They called the persons. The ଶ୍ରଦ୍ଧାଞ୍ଜଳିର ଶ୍ୱଶୁର ଘର ଲୋକେ ମୋ ଅନ୍ୟ ଜେନା ଭଉଣୀକୁ ମିତ୍ରାଣୀକୁ ମହାପାତ୍ରକୁ ଫୋନ କରି କହିଲେ ଯେ ମୋର ଭଉଣୀ ଶ୍ରଦ୍ଧାଞ୍ଜଳି ମହାପାତ୍ର ବର୍ଷାର ଦେହ ଖରାପ, ଏଣୁ ଭଉଣୀ ସେଠାକୁ ଯାଇ ମୋ ଭଉଣୀକୁ ନେଇ ମେଡିକାଲ ଯିବାରୁ ଡକ୍ଟର ତାଙ୍କୁ ମୃତ ଘୋଷଣା କରିଥିଲେ। ଖଣ୍ଡଗିରି ଥାନା ପୁଲିସ ସାର୍ ମାନେ ଆସି ଆମମାନଙ୍କ ସାମ୍ନାରେ ଶ୍ରଦ୍ଧାଞ୍ଜଳି ମରଶର ମୋଚନାମା କଲେ।
I am asking something else, you are reading something else. You said that the girl was recovered by breaking the door open.
That is their house.
Where is that?
That
Who
is
said that?
That I am reading that.
You have not prepared, then I'll put it next week.
No, sir, I am reading.
Last occasion also, the coordinate bench has posed that Suri method. That's the reason it is urgent.
That's the relevant
And it is not
part.
there actually.
I'm passing it over.
Yes, sir.
We can't go like this. Yes. Next.
55.
May I please?
Yes.
Offense under section 302 and 34 IPC, my lord. Petitioner is custody since 15/2/2024, my lord.
Huh?
This petitioner is custody since 15/2/2024.
15 to
2024.
24.
My lord.
Yes.
There is
It is
no,
there.
there is no eyewitness in the occurrence, my lord.
1 minute.
Basing upon the confessional statement, the petitioner has been.
Susili Maji, yes. What is the allegation?
Allegation, my lord. This is along with the wife and son, my lord, went to see the village drama, my lord. After it, all returned, my lord, petitioner stay there. This is stay there, my lord. Eyewitnesses are seen, my lord. At that time, present petitioner and deceased went to a liquor shop, my lord. Petitioner did not take liquor, my lord, but deceased take liquor, my lord. Taking opportunity to extreme intoxication, my lord, he assaulted him, my lord. Raised his neck and he died at the spot, my lord. Within minute, my lord,
Any witness?
this is suspecting, my lord, some relationship with her wife, my lord. That is it. This was arrest.
And what are the,
Only,
who
sir,
are the witnesses?
No, admittedly, no, my lord, eyewitness, my lord, but, my lord, last in theory of 3% are there, my lord. They have seen at 8 to 9 PM night, my lord. Both are near that shop. Yes.
Then those witnesses name?
Yes. So witnesses name, my lord. One, Trupti Maji, my lord.
Trupti Maji, huh?
My lord. And another, my lord, Hon'Ble Singh.
Hon'Ble.
HMBIR, Hon'Ble Singh.
Hon'Ble Singh.
Trupti ne Tipu Maji, TIP, sorry.
Tipu Maji, Hon'Ble Singh. And
Ashish Soren.
Ashish Soren.
Officers are all there, my lord. They are others also there. They are last in theory.
But these are the three vital witnesses.
Of the last in theory.
Let them be examined. Let them be examined. Right. Petitioner is rejected. His bail plea was rejected by the order dated 9/4/2024. The charge sheet has already been filed in this case. It is alleged against the petitioner that the petitioner was lastly seen with the deceased. He made the deceased to drink profusely, and thereafter he throttled the petitioner. I throttled the deceased. There are three witnesses to testify the last in theory. Testify last in theory. Therefore, I am not inclined to enlarge the petitioner on bail on this stage. However, liberty is granted to the petitioner to renew the bail plea after the vital witness, namely Tipu Maji, Hon'Ble Singh, and Ashish Soren are examined. The trial court is directed to do well to see that these witnesses are preferentially examined over all other witnesses. With this observation, petition is disposed of. Next. 66. 66. Yes.
Lordship, dismiss, lordship.
I have given liberty to renew the bail. Yes, next.
My lord, the petitioner is the
66.
close friend, my lord, close friend of the deceased, my lord.
Anyway, I have.
As the he was close friend,
I have already.
police on suspect arrested him and made out.
There are three witnesses those have seen it. Yes, next. Yes, sir.
May it please, your Lordship. Lordship, I am in custody since 29th April 2024.
29?
April 2024.
Yes.
170 gram of heroin, that is 21 B of 170 gram of heroin.
Okay, CD is available, charge sheet copy not available. Final PR.
I have
Final
also,
PR has been filed. A copy of the same is not available with the.
Lordship, already I have filed.
Please the matter after 10. Yes, next. 67. Get the, give the copy. Yes, 67. Next.
May I please, your lordship? My lord, here in this case, initially the FIR has been registered by one orphanage superintendent under section 363, my lord. Thereafter 8 months, the victim rescued from Andhra Pradesh from a maternal uncle house, and basing upon her 161 statement, the present petitioner is entangled.
You are the maternal uncle.
No, my lord. I am another person. And the offense then turned into 363, 354A, 354D, 370, and 12 of the POCSO.
You see, your age is 44.
My lord, if we go through within this 8 months, there is no allegation against this present petitioner. The victim is with the maternal uncle, the maternal, any family members or the victim, they are
You
no.
have custody since?
My lord, since 1/4/2024.
1/4/24.
Mine.
Yes.
Rejection on 23/4/24 million.
20.
Charge sheet filed on 30/5/24.
30/5/24. Go to High Court.
Yeah, victim is admittedly 15 years gal million.
And he is a 44. I have seen it.
Yes.
That petitioner is agreed by the order dated 20th. Order dated 23/4/2024. Subsequent, whereby his bail plea has been rejected. Subsequent thereto on 30th May 2024, charge sheet in the present case has been filed. Since the earlier bail application was turned down by the trial court at the investigation stage, in the changing circumstances, petitioner should approach the court of first instance. If such application is moved, the same shall be considered on merit within 15 days from the date of filing the application. Yes, next.
As per my submission.
May I please before the last?
Yes.
Well, the petitioner is a lady in being custody since 21.
68 million. 302 CD is required.
CD call.
Well, in bill I paid for a breastfeeding child with a
CD, let the CD come out. Yes.
May I please, my lords?
Yes.
My lord, in this case, petitioner custody, my lord, 16/5/23, my lord. 5/23. Basing on the confessional statement of co-accused, my lord, your lordship granted bail. Your lordship the two co-accused persons.
Still case study.
Similar co-accused lordship granted bail basing on co.
In the same FIR.
Same, my lord. Same FIR, same co. Lordship kind. Mutaku copy de
After 1 week. Give the copy. After 1 week. After 1 week. Call for CD.
Mutaku copy de my lord co-accused.
After 1 week. And then counsel for the petitioner submits that in the present case, two co-accused persons have already been granted bail. Copy of the same is supplied to the state council to verify the same. Release the matter after 1 week. Yes.
Good date. Copy touch my lord.
CD to ask CD.
CD was achi co-accused power than dispose of it, my lord.
Connected file also.
Yes. 302 without CD. If I
keep. CD
you speak to him outside. Don't tell me all this. He says CD is not there. Without CD 302, how can I grant me?
Mu bail kotha kohni my lord. CD ta tanko pakhre achi ani jodi ba etiki dos. Aau kichi nui my lord.
He might have returned it out. Yes.
My lord, eta dei debi copy apanko pai. Dita debi.
No, on that day. That day. Yes, next. 70.
Your lordship called for the CD, my lord. Offense under
CD available. Yes.
Offense under 307.
307?
Yes. 506, my lord, non-bailable offense, my lord. The present petition is custody on 25/4/2024. 25/4/2024.
24. Okay.
Allegation, my lord, there is a dispute between villagers with regard to the procession of Maha Sita Bhagavat.
There are two accused.
Two accused, my lord.
See the injuries.
One grievous injury, my lord. One grievous injury.
Which part?
And he was
in the abdomen.
And he was admitted in hospital and released After
discharge
the-
certificate also.
yes.
mentioned. He was also discharged as
Discharge.
mentioned in the schedule.
Discharge and weapon,
Open with knife.
knife.
Yes.
No antecedent, nothing.
No, out of both, who has given the knife blow?
Men
No,
Miller.
6% allegation.
Yes,
6%.
I am placing men.
Chandan Mohan Jena and
I
Vijay
get it.
Jena. Who has given the knife blow?
Miller.
As per the list. One knife is recovered.
Miller.
6 people were there. Who has given it?
Yes. ଅସୁର ଗାଲି ଏପଟେ କଣ ପାଇଁ ନେଉଛ କହି ମତେ ତଳେ ପକାଇ ଗୋଦା ବିଟା ମାରିବା ସମୟରେ ଆମେ ଯାଉଛୁ ତମେ ଚାଲ କିଛି ସମୟ ପରେ ପୁଣି ସେଇ 6 ଜଣ ସଂଘବଦ୍ଧ ଭାବେ ଆସି ହାତରେ ଛୁରୀ ଭୁଜାଲି କାଟି ଠେଙ୍ଗା ଆଦି ଧରି ମା ଭଗବତୀ ମଣ୍ଡପରେ ପହଞ୍ଚି ପୁଣି ସେଇ ପ୍ରଫେସନ ବାବଦରେ ଝଗଡା ଆରମ୍ଭ କରିବା ସମୟରେ ମୋର ପୁତୁରା ବିଜୟ କୁମାର ଜେନା ପିତା ଏହାର ପ୍ରତିବାଦ କରିବାରୁ ପ୍ରଥମେ 6 ଜଣଙ୍କ ମଧ୍ୟରୁ ଚନ୍ଦ୍ରମୋହନ ଜେନା ବିଜୟ ଜେନା କହିଲେ ଫିରତି ଲାଗିଲେ ତୁ କଣ ବେଶୀ ମାମକାର କରୁଛୁ କହି କାତିରେ ମାରିଲେ ପ୍ରଥମେ ଚନ୍ଦ୍ରମୋହନ ଜେନା ଆଉ ବିଜୟ ଜେନା।
You have given the blow.
Well,
You have given the blow. Out of you, who has given the blow?
ପ୍ରଥମେ 2 ଜଣ ଲେଖି କାତିରେ ମାରିଲେ ଆଉ।
What about the other accused persons? They granted bail.
Okay, yes, madam. Who are to bail? Granted.
The charges.
And I believe
Put it up. This is on 24, not even 1 year.
that's a case, counter case, my lord.
What are the counter case?
Your lordship annexer 4, my lord.
Cross case
Annexer
is there?
3, my lord. Our count affair, my lord.
You also got injured or what?
No, we have not.
Who got injured from your side out of 6?
Like allegation is ସେମାନେ ସମସ୍ତେ ସୁସ୍ଥ ଜାଗା ଆକ୍ରମଣ କରିଥିଲେ ଆକ୍ରମଣ କରିଥିଲେ।
It is free fight or what? It's a case of free fight. It's a case of free fight between both the groups.
Not free fight, Lord. They are going in a procession.
Procession is out.
The present petitioners and others came and told that why you are using this path, this road, Lord, using the procession.
Antecedents?
No accident. No accident.
No will
So let them appear before the police station for 6 months.
Yes.
6 months.
Yes.
Okay. Petitioner is accused in so okay. Allegation against the petitioner is so. There is a cross case also filed by the petitioners against the injured and his associates. Petitioners are in custody since 25/4/2024. Along with the petitioner, there are other 4 accused persons aided as accused in the charge sheet. All other accused persons except the present petitioners have already been granted bail. However, the present petitioners were not admitted to bail because there are specific allegations against them that they have given the blow to the petitioner. This is a case of a single blow caused to the victim, which is grievous in nature. Since nothing is illuminating on record as to who exactly has given the blow. I am inclined to enlarge the petitioners on bail. However, keeping in view the nature of allegation of the petitioner, the condition of the following conditions are
Okay.
71.
May I please, your lordship?
custody since 24 years.
May I please, your lordship?
Yes.
Well, allegation under section initially FIR laws under section 363.
363? Yes.
Subsequently, after rescue of the victim, allegation under section 366, 3763, 372N.
Custody?
Custody since 5/1/2024.
57.
5/1/2024. The last occasion, my lord, in the meantime, charge sheet has been submitted. Kindly have glanced the order dated 1/8/2024. Deposition would assist.
Deposition before the court.
My lord, my lord. Victim
these are not classified document in the field over. You read it and see.
Yes.
So give a copy to the prosecutor. And next week, let him read. Next week, huh? Next week. photocopy करके दे दिए
आइए
देखिए ठीक next 72 yes 72 what is there yes diary
Yeah, available.
offense
302.
nobody appeals there please
Yeah, attended.
huh
Non-applicant not attended.
non-appear in the interest of justice urgent to for no more
73.
73
Not 73, 376 CD is required.
CD called for yes non-appear for the petitioners call for CD yes
74.
yes
Lady, my lord.
huh
Petitioner lady, my widow lady, man.
yes custody
Custody since 4/4/2024.
CD
CD available.
huh what is
Custody since 4/4/2024, my lord.
Yes.
FR date 3/3/2017, my lord. FR registered against 2 number of accused person, my lord. FR more 99, my lord. And petitioner implicated basing on statement of co-accused, my lord. Co-accused petitioner son, my lord. And co-accused already granted bail, my lord. That is page
302
yes, ma'am.
yes
Page 33, my lord.
says that except
Present the mother of the co-accused. What happened, my lord? Present witness suspecting, my lord, deceased had killed his wife by using, my lord, witchcraft, my lord. That's why number of witnesses are seen, my lord. Son of the present petitioner took the deceased to unknown place, my lord, where present petitioner is available there, my lord. Thereafter, by helping of the son, my lord, present petitioner killed the deceased, my lord, and cause of death, my lord, by cutting his neck, my lord. 7 injuries in his neck, my lord. Cause of death, cardiopulmonary arrest due to shock and harmless. And 7 injury in the neck.
Neck.
No, admittedly, no eyewitness are there, my lord. But he is suspecting her husband was died due to witchcraft by the deceased, my lord. So, son of the present petitioner, my lord, with help of another person, took the deceased to unknown place, my lord, where
this lady has was
available
there
with
she has
knife,
committed the
with
crime
knife, my lord. She has
committed the crime son of the son of the petitioner has already been granted
Granted bail, page 33,
so
man.
33
man.
33
BL pen number 9416/2017, man.
33 where is that 33
Yes, ma'am. BL pen number 9416 of 2017, man.
trial court granted bail
No, no, High Court, man.
where is that
Order, rejection order set reflected, man.
it's not
Page
there
33, man.
the item which is the item
Para number second, man.
74.
74 where is that 34
33, man.
it's not there sir where is that it's not there
Rejection order, man. Page 33, man.
it is not there
Yes, ma'am. Mention is 9416/2017.
am I telling lie it's not there
I would read.
file that
Mo pakhre order upload hai, man. Rejection order reflect is, man. Page 33, man.
you say rejection order 34 huh? You say that I was searching the High Court order yes where is that
Yes, man. Page number
34 huh? Yes
33, man.
which part
Second line, man.
yes
The original case record TR number.
it's not uploaded
No,
Super.
no.
Just check it up it might be uploaded by now check it learned counsel for the petitioner submits that the co-accused who is the son of the present petitioner has already been enlarged on bail by this court while allowing BLAPL number 9416 of 2017
Madam.
isn't it
Madam.
2017 let him place on record the said order please the matter after 1 week yes 75
May please, Lord.
she was absconding or what? She was absconding.
Yes, ma'am.
She was absconding. That's the problem.
After MDW arrest, man.
Because 2017 he got the bail. You have been absconding.
You were arrested on Miller 4/4/24.
Ah, that's what I'm
Milord.
wondering. Right now, no. Oh, you are absconding, then no question of it. Yes. 75 na? 70? 74, right on. And let him file it. Let us see.
75 may I please, Lords? My lord, offense under section 420 and 506, my lords.
420?
And 506.
506.
The
Custody since?
Custody since 8/4/24, my lords.
24. Yeah.
My lord, allegation is that on 19/8/2023, my lords, I told the informant that I have a gold conch and the amount is 4 crores and I will sell it for 5 lakhs, my lords. And I gave a sample and he tested and found that it's a gold. It was gold, my lords. Subsequently, on the next date, he took the gold conch and paid me, my lords, rupees
5 lakh.
No, my lords, 4,35,000.
Yes.
4,35,000, my lords. And after 7 months, he lodged an FIR, my lords. Stating that
It was found that it's not gold Miller, it's just silver. So, yeah.
He also greedy, he was also greedy. Both of them were so greedy.
5 कोटी को 4 लाख कर दो ये 4 लाख और 5,000 दे ही नहीं गया यार.
Why don't you pay it back and I'll quash the FIR? Pay the entire money.
my lords, he's a poor man, my lords, and whether
Poor man, you have taken the money, what
there
for?
is no transaction details, my lords, regarding whether the money was given or not, and that has to be ascertained, my lords, whether that money was given or not, that thing, my lords.
I am enlarging.
Miller.
Petitioner is accusing the FIR. The allegation against the petitioner is also. The petitioner is in custody since 8/4/2024. The charge sheet has already been filed on 6/6/24 for alleged offence under section 420 and 506.
420, 506, 34.
34 IPC. The sole allegation against the petitioner is that he has sold a gold conch for an amount of about 5 lakhs, after 7 months of purchasing the same from the petitioner, the informant realized that the conch was not a gold one, rather it was a silver one, and coated with gold coated silver conch. Therefore, he filed the FIR. Regarding to the nature of offence, the period of custody from 8/4/2024, I am enlarging the petition on page.
77.
Withdraw. 77 withdraw. Yes.
78.
Withdraw.
My lord, custody since 21/4/24, offence Act 21B of NDPS Act, allegation, my lord, that the informant suspected to accused person for possessing of 11 gram contraband brown sugar. Charge sheet already filed, my lord.
Yes.
Lord, 11 admittedly 11 grams, Lord. But he has involved in 7 cases, my lord.
7 cases you have.
My lord,
7 cases.
one similar type of offence or other cases are available.
That's the problem. That's the problem.
My lord,
File an affidavit.
Let him file and complete.
File an affidavit. Let counsel for the petitioner, the counsel for the state submit that although the recovery for the contraband brown sugar is only 11 grams, but the petitioner is involved in as many as 6 cases. Land counsel for the petitioner seeks adjournment to file the affidavit, giving details of the cases the petitioner is involved and the status of those cases. Release the matter after 3 weeks. Yes.
79.
My lord, I am in custody since 15/12/2023. Case has been charge sheeted and where the victim also made an affidavit before the law and court stating there in there due to torture from my mother and grandmother, I came to the house of the petitioner and gave birth a child. And she is
Custody since?
Custody since 15/12/23.
15/12/23. Okay.
Victim is also present before this in campus, my lord. But offense are on 363, 34, 376(2)(n), 366, 376(3), 344, and 6 of the
Pass over, I'll take it after lunch. Yes, sir. Sir is waiting for.
What happened, this matter was dismissed for default. And then, my lord, it has been restored. Then it has come before my lord and it is listed for hearing. As if that notice has to go because the right is accrued to the respondent, my lord. For the purpose of-
94?
Complaint.
I'll take it up. after
98.
No, I'll come after lunch.
Yes. Oh, yes.
Senior counsel is waiting, so therefore.
That
I'm just
matter,
taking up. Yes, 94. Okay.
98.
Yours is 98. Okay, 98.
Complaint case.
Yeah.
Other complaint case.
Notice has to go to opposite party.
Yes, my lord.
Okay. Issue notice to opposite party number 2.
Yes.
Opposite party number 2, returnable within a week. Tell me the date when can you be there. Now, whenever you are there, then you tell.
I'm not very sure if I want. First October.
No, not 1st
No,
October.
Not possible.
1st October.
Notice, yes, sir.
I think you won't be there on that day. Let it be after 3rd.
Yes.
After 3rd. After 3rd, any day. Huh? File the requisites immediately.
Yes, yes, ma'am.
Requisite to be filed within 2 days, 2 working days. Leave the matter after 3rd. Give a fixed date.
In this case,
I noticed that too also.
I notice in both.
There are 3 matters where it has compromised. It's the only one that it has not been.
Compromise this also. NVW stay. Where is that NVW? I number? Meanwhile,
2457.
24.
5724.
In the meantime, the NVW issued by the court below by the order dated. Where is NV?
Order is not done, but stay was granted earlier, my lord.
You tell me NVW when granted, I'll stay the operation of
Stay was
that.
granted earlier, but it was, my lord, because of the case closed.
I can't pass an order without knowing anything.
No, my lord.
You tell me the date of NVW, I'll stay that.
I have filed a further motion stay.
No, NVW, tell me. If NVW is issued, give me the date, I'll incorporate. You call your briefing counsel and tell me, so that I'll say the operation.
Stay was there initially. I think the NVW has not been issued.
NVW. Be sure what you are saying.
No NVW.
No NVW. No.
Further
Okay, and Mr. Das, the senior counsel, submits that you would be moving an application for adjournment before the trial court, owing to the fact that the matter is of jurisdiction before this court.
Hey, Jyoti.
I filed the joint affidavit.
And what way you have to draft, you know that.
I will.
Twice I have given the time. Next time I will dismiss it.
I am pardon. Your Lordship, I will call.
Next
weekend.
Next. Tuesday. Yes. Aseva Podio.
Hello.
Aseva Podio, because see, this life of this girl is involved. Yes, next.
May I please, Your Lord?
Yes.
My Lord, Your Lordship has order on dated 23/8/2024. Land Additional Session Judge cum Special Judge, Koraput, is directed to furnish a status report before this court regarding the stage of the trial in this PLAPL, my Lord.
12, item 12. Yes, the bail matter. Yes.
Bail matter.
Yes. Yes. You have the status.
My status was not, but I have received the charge sheet and
No,
also,
no.
my lord, the
Where is that order?
chemical negligence report, my lord.
Where is that? Status report of the district court status report is there? Huh? District court status report. When was that order? Order is 23/8, huh?
My lord.
23/8. Status report is. Status report hasn't come, huh? 27, it has come.
Trial court से कोई
One witness has been examined out of 14. Custody witness. Yes, one witness. You are in custody since?
Since 24th June 2021.
Yes.
My lord, here's my lord. Preliminary charge sheet submitted 19/12/21, my lord.
19.
My lord, keeping the investigation open, my lord, there are other accused who fled away from the vehicle, my lord. And this petition is the occupant of the vehicle and 153 kg of ganja recovered from the vehicle, my lord. Petitioner belongs to outside Bihar, my lord. Belongs to Bihar, my lord. Thereafter, the seized ganja sent for chemical analysis report. Chemical analysis found that this is the ganja, my lord.
He is in custody since 24/6/21.
My lord.
Out of 14 witnesses, only one witness is examined.
My lord.
Material witness, how many material witnesses?
My lord, there are, my lord, other material witnesses are there, my lord. Total, my lord.
14.
Total material witness.
Total 16 witnesses, my lord. Out of 16 official witnesses.
14 witnesses.
My lord.
And my lord, in charge sheet there is 14 witnesses and one has been examined.
Okay,
Lak-
then I
Lakshmi Narayan Khora.
Petitioner belongs to Bihar, my lord.
Yes. Right on. Pursuant to the order dated 23/8/2024, the district additional sessions judge, special judge Koraput has furnished a report entry earlier stating that out of 14 charge sheeted witnesses, only one witness has been examined. And there are other material witnesses yet to be examined. The petitioner petitioner's bail application has been turned down by order dated 10/1/2024. 10/1/2024. Thereafter, the material witnesses, one of the material witnesses been examined, and the matter was listed for hearing on. Matter has been today is what is the time? What is the date today? 12. The matter is listed for recording of evidence on 12/9/2024. In view of the aforementioned development, the petitioner is given liberty to renew the bail plea before the trial court. Trial court immediately after the material witnesses are examined. If the material witnesses cannot be put, cannot be examined for any reason whatsoever, the petitioner is given liberty to renew the bail plea after the expiry of 6 months. With this observation, the petition is disposed of. Yes. Next.
17.
Yes, sir. Bail.
Last occasion also I filed the deposition copy of the alleged
Yes.
team. That is flag C, your lordship.
Flag C.
Flags.
Custody since
Custody since of 9/11/2023.
9/11/23.
23. The
Yes.
victim turned hostile. And there is no medical report at all. Victim age 45, my age 26 or so.
The last month of the current took child, the accused being my cousin.
For viral part is concerned, there is no material.
To our house frequently, relevantly.
Photo has been seized.
Like to our house at that time. Passing along, he told me, I do not know as to why I am coming to your house. I love you, and I was my hand and so there was moving by saying so all of the suddenly migration
Paragraph 9, code hostel 154. Reading question
Brought out immediately, kept near his waist and threatened to kill the footage. Then made method and captured my progress and everything. The witnesses supported the prosecution.
Yes, only so far as the allegation 370.
Why do you say it's not supported? For a minute detail, he is narrating.
Page 2, you also the question, you also after paragraph 9, you also.
You can't read one line somewhere.
No, entire detail is 150%.
Or a 3 is vital, my lord.
76 part is
No,
Deposition.
prosecution witnesses
there you also.
examined.
There is
Para
no
3.
allegation regarding 376.
Para
Only
3 clearly
allegation-
mentioned.
The FIR also class, the FIR contents is there, you also. When the
Forget about now FIR. The witness, the victim has been examined by the court
Yes,
as PW 1,
yes.
who has completely supported the case
No, so far
and
rape part
narrated
is
that
not there, Lord.
how you have
No, so far
committed.
rape part is not there, Lord. Rape part, but evidence is not there. Lord, we have gone through, Lord. Rape part is not there. Therefore, he has been declared hostile. 151 leading question is put to her, Lord.
Keeping the brutally honor soldier.
And you have taken
forceful-
nude
yes.
picture and attacked her.
This much, that photograph
This
has
much
been
is
taken and it has been viral.
Photos-
Thereafter, so far the other part is concerned regarding
Victim
rape
and
is
one
not
of
there,
our
it's not
is
there,
our
Lord.
friend.
Rape allegation is not there, Lord. If this fact is taken to consideration, the Immoral Traffic Act and Section 3.
And you made the viral, the big
Yes.
this thing.
That viral photograph has been made viral one of Trilochan Pradhan. That has been seized from the Trilochan Pradhan.
So far the mobile and SIM has been seized. No
Whatever.
photocopy has been
No,
seized.
allegations.
Oh, no. Let's make a glance.
This is recorded on.
And the CDR, let's have a glance.
1 minute.
The
Recorded on.
CDR, this post occurrence, they are in frequent talking alerts. They are CDR alerts. This post occurrence, they are frequent call alerts. In the FIR, they stated that they were in love and with fear she committed a rape. For a later stage,
Okay.
when the deposed.
Okay, the petitioner is agreed by the order dated 30th January, 3 January 2024. Thereafter, the victim girl has been examined with PW1 on 8/5/2024. In the changing circumstances, the petitioners may renew the bail plea before the trial court. If such bail plea moved, the same shall be considered on the basis of the material available on record. Yes. Next.
Let's say let pay Lordship. Lordship not inclined. Trial may be targeted Lordship because I am in custody since 9/11.
No, I am giving you liberty. You argue this point there.
At least your Lordship.
How many witnesses are there?
Lordship, all total agent today Lordship outer
21.
21 witnesses, only 4 has been examined. And I am posted since 2020, November 2020, 23.
23 only.
November 2020.
Not even a year. Wait. Yes. Next.
27.
Yes. 27.
Please, your lordship.
Yes.
Sir, I am in custody since 29th of January.
24.
24.
Yes.
FIR is 7th of January, my lords.
Hmm.
If your lordship will look at the FIR, which I have annexed at page 14.
CD is there?
Yes, my lord.
Yes.
CD is there and 164 is also available.
In our FIR, this is what she says. That fourth line I am placing.
Read here 164.
My lord.
Straight away.
My lords, before that, your lordship will
Yes.
just see the FIR.
Yes.
Fourth line. ମୁଁ 2022 ମସିହା ମେ ମାସ ଠାରୁ ସରୋଜ କୁମାର ସ୍ୱାଇଁ ସହ କଥା ହେବା ଆରମ୍ଭ କରିଥିଲି. Then your lordship may see 2 lines thereafter. ସରୋଜ କୁମାର ସ୍ୱାଇଁ ପ୍ରପୋଜାଲ ଦେଇଥିଲେ ମେ 2022 ରେ, ତାପରେ ଆମେ କଥାବାର୍ତ୍ତା ହେଉଥିଲୁ. ଆମେ ଅଗଷ୍ଟ ମାସ 23 ମସିହାରେ ସରୋଜ ମତେ ନେଇ ବାରଙ୍ଗଠାରେ ଥିବା ହୋଟେଲ ଅୟୋକୁ ନେଇକି ଯାଇଥିଲେ. ଆମ ଭିତରେ ଶାରୀରିକ
Charge sheet submitted.
Charge sheet.
Charge sheet submitted. Lord, I have the copy.
Tell me the date.
Sorry,
Tell
madam.
me the date. Charge sheet date.
21/7/2024.
21?
7/2024.
Decision 29 for 2024.
That's another problem for you. See, your bail application was rejected at that point in time when the FIR was for 203.
My lord.
Subsequently, the charge sheet is filed. Right down. Petitioner is agreed by the order dated 28/3/2024. The FIR was registered against the petitioner for alleged offence under section 498A, 302, 304B, 34, reduced section 4 of DPS. Subsequent thereto, on 21/7/2024, the charge sheet has been filed, where the offences and offence under section punishable under section 302 has been dropped. Since the petitioner's bail application was rejected during the period of investigation, and subsequently charge sheet has been filed in the changing circumstances, petitioners should approach the court below by renewing his bail plea. If such bail plea is moved before the trial court, the same shall be considered on the material form part of the charge sheet within 15 days from the date of filing of the application. Yes, next.
79. My lord, I am custody since 15/12/2023, my lord.
15/12/2023.
Case has been charge sheeted for the offence under section 363, 34, 3762N, 366, 3763.
Yes, charge sheet filed
on 12/2/2024.
Charge sheet filed.
My lord.
Yes.
The victim also given affidavit before the POCSO court in where she stated that due to torture from her mother and her grandmother, she left to her own house and lived with her husband. The victim has also given birth a child, and she is living in the house of the petitioner.
Now she is 19 years.
My lord.
You are 22. You are married.
Married, both married, given birth a child.
Where is that? Where have you said that?
My lord, it page 26, my lord.
26.
Annexure 2.
Yes. The major represented 19 years and that I blessed with the child born in so and so and discharged sleep so and so. Myself and the accused Bhaskar Bagh have compromised dispute, intervention in our villages well wisher. You married with whom?
Well, petitioner.
Petitioner. Yes.
Number one, sister point.
She is married, 19 years, having a child.
Whether she is remaining with the.
See, that is what I
My lord, she is here, my lord. Victim is here.
Call her. Ask her. With the intervention of our I do not want.
Lordship, what has happened in this case? The informant was in need of a gold loan. So she contacted one of her friend. That friend gave number of the present petitioner.
How much? What is the amount?
1,30,000, my lords.
130.
1,30,000. The petitioner took that gold from the informant and deposited in the bank and did not return the money. This is the allegation. Thereafter, my lords, FIR was lodged. Police investigated the matter. Police approached the bank, recovered that gold ornaments, returned to the informant, and
You had taken the gold from the informant.
Deposited in the bank.
Mortgage it in the bank and pay the money.
Lordship.
You mortgaged, but you didn't pay the money.
Lordship.
That's the
Lordship. That is the allegation.
And now money is paid to the bank.
Money is paid to the bank.
Who has paid?
Lordship, my father. I am in custody. My father.
Okay, I
has-
am granting the. There is nothing.
Yes, filed an IA, my lord. There, your lordship is asking to take instruction.
IA for?
It was, my lord, listed on.
1 lakh.
My lord,
Why entry?
the fact is correct, my lord. As per.
He is entitled for regular bail. Why?
Well.
Granting regular bail. Right on. Petitioner is accused and so on. Allegation against the petitioner is censored. And after investigation, charge sheet has been filed on 30th July 2024. The sole allegation against the petitioner is that he has taken gold ornament from the informant to mortgage in the bank and pay the mortgage amount to the informant. However, it is alleged that the present petitioner, although mortgaged the ornament in the court, but after availing the loan amount, he has not paid it to the informant. Subsequent during investigation, the father of the petitioner has paid the loan amount and released the mortgage gold and returned it
No,
to
no,
the-
Lordship. During investigation, police seized that gold.
You
gave
paid
it-
the money.
I paid my father paid
During
the-
investigation, the police seized the gold from the bank, and the father of the present petitioner has paid back the loan amount.
Lordship.
Paid back the loan amount. Petitioner is in custody since 8/6/2024. Regard being had to the aforementioned and period of custody granted bail. Yes.
Deep privileged.
Bill. Yes.
81.
81. Yes, sir.
Lordships, I'm for the opposite party also.
Yes. What is this?
The states appealed. States has filed this case for. In fact, in this case,
But he has religion bail, my lord.
What is he asking for?
State file, my lord, for cancellation bail, my lord.
Cancellation of bail.
My lord.
Okay.
But
why?
The court, my lord, religion bail the petitioner, my lord, only because the IO has not complied under section 47A of CRPC, my lord. And for that reason, he has granted bail, my lord. But in fact, my lord, the court, my lord, stated in the same order, my lord, that the IO stated that since there is, my lord, every possibility the accused person committing again and again similar type of offense, my lord. Here, my lord, two elephant, my lord, the killed by the petitioner and others, my lord. The electric wire, my lord.
No, merit, I don't want to
My
go.
lord.
Why are you interested to get
But the order, my lord, is still, my lord, illegal as because, my lord,
Where
he
is
has
that?
not.
Where is that?
your lordships, page 14, annex 1.
Yes.
Lordship, kindly see the order.
But the page 16 points.
Yes.
The
41A you are giving.
forester arresting the present petitioner has prepared a checklist. There has been explained that
Where are you reading? Where are you reading?
Page 16.
Page 16.
Okay. Yes.
Explained that she did not serve notice 41A CRPC for the reason that the offense is unavailable and there is possibility of committing such offense again and again. The arresting officer has not recorded any fact basing on which she formed the above opinion. Thus, I hold that arresting officer has not complied provision 41A.
You say that he has complied.
And he has
Since, my
been,
lord, there is possibility, my lord, he will again and again commit similar type of offense. For that reason, my lord, 41 notice not issued to him, and I arrested him, produced before the court, my lord. Within 1 month, my lord, he has granted bail, my lord. Since, my lord,
You have applied to the court below for cancellation.
yes,
no, my lord.
Huh?
My lord, since, my lord, sessions court, my lord, the POSCO court, lower court rejected, my lord. Thereafter, they
Sessions has been granted
additional
bail.
session judge, my lord.
Additional session
Sessions
judge
has been
granted
granted
bail.
Bail, my
Yes,
lord.
You go there only. Why should you coming here?
My lord,
and your lordship,
since
not
but
only,
if,
not,
if the magistrate granted, but then only I approach there 437 5 my lord. Since the sessions has my lord, granted
No, it's
bail,
on the you say that is
my lord, that
misrepresentation of fact.
my lord.
And the sessions judge has committed error by granting bail. He go to that court. Go to that court. Let
and,
counsel for the
your lordship,
state.
may
That observation disposal.
I am observing and let him go on. Let counsel for the petitioner. The state petitioner state na.
State.
Petitioner state. Mr. Raghuda, let counsel for the state submits that the state is agreed by the order dated. Where is that?
8/2/24.
Order dated 8/2/2024, whereby the bail has been granted to the opposite party number 2. He submits that the bail has been granted by the court below only on the ground that statutory notice under 41A CRPC was not served on the opposite party number 2.
And maybe-
Be that as it may, I am not inclined to entertain this petition. However, liberty granted to the petitioner to move appropriate application before the learned court of additional sessions judge come special judge under Nagar for modification of the order, modification of the cancellation.
Cancel
the order. If such application is moved, same shall be considered on its merit disposal. Next.
82.
Yes. 820.
Your lordships,
82 my lord.
without same 82 is
Go
same
ahead.
lordships.
Go ahead.
Lordship may say
Go ahead, same.
without merit going to the merit of the
Without
lordships or not.
without going into without going into merit, they are sending. 82 also same disposal. Yes.
83.
Bail is granted unnecessary.
Depend on lordships, not only on the 41 ground lordships. On merit also he has been granted bail.
41
The bail lordships have not been violated any terms and
Anyway,
conditions of bail.
let them move application. It will be rejected again. If they will come, you will get that another. Yes.
May I please, your lordship?
Yes.
My lord, this is an application for cancellation of bail granted to the OP numbers. Grounds are, my lord, the IIC Loisinga PS under Annexure 4. Filed an application, your lordship, may kindly see page 26, Annexure 4. This is the application of the IIC Loisinga PS before the JMFC Loisinga that the present opposite party number 2 to 4, my lord, they are involved in 10 cases against the same persons because the petitioner has purchased a piece of land from the elder brother of this opposite party number 2. Therefore, my lord, they are running havoc and they are not allowing them to live peacefully in the village. 10 cases have already been instituted. And my lord,
These cases are instituted after the bail was granted.
no, my lord, one case is again. In this bail application, your lordship may kindly see the conditions.
Where is the bail order?
Bail order is page 24-25, my lord. Annexure 3. Conditions are at page 25. Your lordship may kindly see.
25. Okay.
My lord. They shall not commit.
commit any front, so they shall cooperate with the investigation.
Lord.
They shall appear before court. Yes.
Thereafter, my lord, again, my lord, they committed the offense for which Loisinga PS case number 300 of 2023 under Annexure 5 has been lost.
Yes.
Thereafter, the IIC filed the application before the court below. But Land Court below has opined that cancellation of bail is a separate matter. So, with great respect, my lord, the cases is not being taken up for hearing or for trial.
I'll add condition. What condition you mean? Further condition.
My lord, further, my lord, they will not terrorize us and no further. And there is an injunction order.
You will appear before the IIC Loisinga police station every Sunday for about 6 months.
And
no,
if
no.
you
10 cases you have. I'm not cancelling.
And your lordship, so please may target the for trial of these cases, my lord.
Right on. Petitioner is agreed by the order.
That's a descriptive order, your lordship.
1 minute.
The case which he is citing, your lordship, after the occurrence, it's a case and counter case. That was taken by the court.
Whatever conditions has to be imposed because you have 10 cases.
That was
now
not a
11.
gentleman.
That between the same party, your lordship.
Whatever.
In respect of the same property.
You may commit further.
Case and counter case.
Okay, it's all right. Right on. Petitioner is agreed. Petitioner is the informant.
The petitioner is the informant, my lord.
Informant in the FIR in the PS case number Bolangir.
No, but Loisinga PS case number 169 of
169 2000. The opposite party number 2 is the
2 to 4, my lord, are the accused persons.
Are the accused persons. They have been enlarged on bail by order dated 13/9/2023 passed by JMFC Loisinga. Learned counsel for the petitioner submits that the present petitions are involved in as many as
12 cases, my lord.
12 cases, out of which one of the cases has been registered subsequent to the grant of bail. Therefore, he seeks indulgence of this court for cancellation of the bail. I am not inclined to cancel the bail granted by the court below. However, I am of the opinion that appropriate condition, keeping in view the antecedents of the opposite parties, appropriate condition should be imposed on the opposite party as being bail condition. Therefore, the petitioner is given liberty to approach the court below for addition of further condition. Addition of the further condition against the opposite parties. Opposite parties. With this liberty, the petition you move application.
Let your lordship may not target, but say the trial court to expedite the trial only, my lord. Only to expedite.
No, I don't know. 10 cases. It's so huge a problem for trial court, but the high courts are unnecessary without knowing anything, targets the cases, and it creates a lot of problem there.
My lord, your lordship may
It's
say,
very
I-
easy for you to make a prayer,
Lord, I will
and
file an-
easy for me to add a sentence, but it creates a lot of problem.
My
for
lord,
this
my
trial
lord.
court.
Your lordship may say, my lord, I will file such application as per my lord's direction within 10 days, and he may pass necessary condition within a time frame.
If any such application is moved by the informant before the trial court, the same can be decided within 15 days from the date of moving.
Grateful, my lord.
Yes. 84. 84.
Lord, prayer for quashing of the FIR vis-a-vis the proceeding, Lordship, vigilance proceeding.
Yes.
Since last 4 years, Lordship, the case is pending. Case pending means the FIR is pending and no charge sheet has come as of now. In every vigilance.
Vigilance Council.
Yes. Vigilance Council is not there.
Mr. Maharana.
Mr. Maharana is not there.
No, last time.
He's not, he has a personal problem. After 25th. Huh? Yes, next.
85.
Yes, madam.
Passing of FIR and charge sheet subsequently filed with the Vigilance Department in Baleshwar PS case number 16 of 2021, and the FIR has been registered under section 13(2), reduced 13(1), C and D of PCR 120B 467.
What do you want? Passing?
Passing of FIR. Because there is the allegation made in the FIR do not constitute any offense, and the evidence adduced in support of it do not make out any case that I'm going to.
This is also vigilance case, Mr. Maharana.
Charge sheet filed.
Charge sheet filed, my lord.
You argue all this thing in the stage of charge, whether it's made out or not made out.
Not committed, and it is due to the erroneous and wrong calculation by the inquiring officer. The FIR has been registered, which is prima facie in the
Corruption cases, they can't be costly.
Mr. Maharana's name is there.
No, I'm giving liberty to you to argue all this thing point at the stage of framing of charges.
Prima facie case within 2 to 3 lines, I will substantiate how erroneous and wrong.
Show me. If I
Yes.
can.
You let's say kindly see page 182.
180?
2, running page.
Yes. 182.
This is the inquiry report on the basis of which the FIR has been registered.
Lokayukt has inquired about it.
So, Vigilance Department has inquired into it.
On the
by the direction of.
direction of Lokayukt?
Yes.
Yes. Yes.
The second paragraph says, my lord, during the spot verification.
1 minute. 180?
2 minutes.
It is such an exhaustive report consisting of about 200 some pages. You are reading one line somewhere and saying that quasi.
One paragraph is substantiate and I will prove that how erroneous.
Read it. During the spot verification,
During the spot
it was found that.
It was found that the rubber samplings had been planted in 4.5 meters into 4.5 meters distance, and it is requirement as per the rubber board guidelines. In 1 hectare, although 479 rubber sampling can be planted, but 470 rubber samplings are generally planted in 1 hectare of the land, leaving corner of the plots, etc. It is found that rubber sampling had been planted in 245.72 hectares of land as such, in 245.72 hectares into 470 per hectare is equal to 1,15,000.
Yes.
1,15,480 rubber.
I read it. Now you tell me.
As per this paragraph and as per the
this calculation is wrong according to you.
One subtraction, you'll have to kindly see. The EU says that 1,15,480 number of rubber plants should have been planted, but the information has been given by the ITDA Ganja that 1,40,147 number of rubber sampling has been planted. In this process, 29,608 excess plants are being planted. On the basis of that, the FIR has been registered. If we subtract 1,40,000 or 147 minus 1,15,480, it is not 29,608.
This thing, madam, can I do it at this stage? Out of about 150 pages order, 150 pages order, I will read one paragraph and I'll calculate it and pass the cognizance order. In a Prevention of Corruption Act inquired by the Vigilance Department at the instance of the Lokayukt of the state.
fact, may not, but a person who has committed a sleeve of mistake in the entire inquiry.
Maybe, but
Because
see,
that the poor persons who have served the department and we may not add to add to it, may not, in the first report, may not even think, you know, kindly see page 112.
at this stage, I am afraid I can't go into all this.
You know, he has observed that the records do not reveal any evidence of misappropriation in the first report. Kindly see page 112. 112 mean. 112.
The report starts thereafter.
112 first.
The report starts thereafter.
Which
100
this is
pages.
the conclusion. This is the conclusion and recommendation of the first report and final report by the Vigilance Department. Below, after inquiring with 13 different officials from different departments. This is the conclusion and recommendation.
Yes.
The case record do not reveal any evidence of misappropriation of funds on plantation of rubber sampling in above 19 projects made by ITJ Ganja during the year 2013-14 to 2016 and 17. And in the last part of this year, he has recommended for departmental proceeding. Your Lordship may kindly see the last paragraph. As such, the following officers are responsible for lack of proper maintenance and supervision of the rubber plantation project, for which there is no plant in some projects and very, very negligible plants in some other projects. It is therefore prayed to consider for taking regular departmental action against each.
What is your name? Your
Gangadhar Naik.
Gangadhar Naik. Gangadhar Naik. You are the first person. TA2 ITD. Additional secretary.
I'll add some point here.
What happened to the departmental proceeding?
It is going on.
So then, departmental proceeding is also going on. I think you should withdraw and take the liberty to argue all these things points.
They have been suffering for the last 3
Maybe, but
years.
what to do? What to do? I can't perhaps quash the entire proceeding at this stage.
Time I will in details, I will give you
Madam, at the cognizant stage, can I doubt this 200 pages inquiry report? I have to read everything line by line and quash the cognizance order like this.
I will give in concise my points of
You can't reduce the inquiry report.
Page number, I will apply you.
If you have not prepared, that's a different story. You prepare, but I don't think you have a case. What best can you take from this court? You tell me. I am ready to give you within the framework of law.
I will satisfy you.
You are on bail.
Are
you on bail?
Yes.
You are on bail. No problem.
Yes.
You are on bail, and departmental proceeding is still going on. And Lokayukt has given a report.
After departmental proceeding, which is genuine for the lack of.
Okay, if you want time to further argue, I'll just accommodate you. Keep it after 25th.
86.
But you have a difficulty. Anyway, you right.
Yes,
yes, no problem. Yes.
86.
86.
Here your lordship asked the state to find out, my lords. This is that proceeding where because of that Jindal's mining activities, my lords, the village has been made into 2 groups, my lords, and
yes.
FIRs and
I have
counter.
obtained the case diary, but in fact, one notice issued, notice could not be issued due to late filing of the.
Why are you not issuing?
Late filing of requisite.
You are instructing counsel. The process, the requisites were filed to serve opposite party, private opposite parties.
I think that was because of the fact that there was a holiday and the matter.
Anyway, I'm just utilizing that requisite.
Yes.
Serve the opposite party. Release the matter after 25th. No, his matter is fixed.
27.
The other matter is fixed on that. 27. Okay.
And interim orders.
87.
Your lordship, the noting is that your lordship, the notice has been returned back. So notice has been returned back. So again, your lordship, may I permit to take the notice?
Not sufficient. Notice on opposite party number 2 is not
in the
sufficient.
same address. I will take the
and fresh steps to be taken by the petitioner. Release the matter after 3 weeks, interim order to continue. Yes.
May you also pray one thing, your lordship, returnable short that your lordship.
He's giving it.
Your lordship.
88.
Interim order to be continued.
Interim order to continue.
Deep problem.
Yes, 88. What is this matter? $125. Husband, what? Private. Maintenance. Non-appeals for the petitioner in the interest of justice urgent December. 89.
89, my lords. I'll file the charge sheet copy, my lords. Next week, my lord. Passing of the
Next week.
proceeding.
What are you asking for?
My lord.
Criminal proceeding.
Passing of the proceeding, my lord. Is a juvenile. My lord, I'll file the charge sheet copy next
Let
week.
the
my lord.
counsel for the petitioner submits that he would be filing the copy of the charge sheet within a week. Release the matter in November last week. Yes.
Next week, my lord. Next week. Next week.
Not next week. It will go to November or December. Not beyond that. Otherwise, argue right now. We are struggling hard to get the matter listed. Once the matter is listed, you are asking for adjournment. We will go to December. Put it in the December, first week of December. Otherwise, argue the matter. How difficult to adjust the matters?
Question of
criminal proceeding means under the section 399/402.
I know, I have seen it. There is nothing on that. I have seen it. December first week. Yes.
November, my lords.
90?
May I please your lordship?
December. Whoever will ask adjournment will go to December. Yes.
May I please your lordship?
Yes, sir.
The
Yes,
petitioner challenged the DB criminal miss case
Yes.
120/2023.
Your husband.
I'm the maternal uncle-in-law, the mother-in-law, and the husband.
Okay. What is the order? TV order?
I'm challenged the total DB proceeding.
Proceeding.
My lord. It's because the the opposite party left the house on after about 7 years.
What is the order made in the DB proceeding?
DB proceeding order. Not
Any order.
the proceeding may be stay, my lord. Stay.
No, I will not stay. I'll send it to mediation. Because it's the matrimonial dispute.
My lord,
Right?
opposite party is not interested to return back the house of the
Then
petition.
it's all right. Then she will tell in the mediation center, we will quash the entire proceeding.
My lord.
Right on. Issue notice to opposite party number 2. The present dispute is arising out of a matrimonial discord. Therefore, the parties are relegated to where are you? In Cuttack, na? Cuttack. Okay. To High Court's mediation cell for exploring the possibility of mediation settlement. The coordinator of mediation cell is directed to fix a date and communicate the same to the party concerned. And after exploration of the mediation, report shall be placed before this court. Please the matter. Yes. 91.
Oh, yes.
File the requisites. And the counsel for the petitioner also undertakes that the copy of this order she will communicate to the opposite party. Yes. Yes, sir.
My lord was pleased to hear me at the stage of admission and was issued notice. My lord, kindly see my lord's order dated 8/2/2024. Virtually, my lord has considered while granting stay the merit of the case.
Against the plaintiff, the allegation is FIR and the charge sheet indicates that on the mother-in-law of the complainant was died. Mother-in-law of complainant, they had brought the dead body from the hospital and kept the body in front of the house of the complainant. At that time, the construction work of the building was the accused person. The complainant asked the worker to stop the construction work of the building till the rituals is about to this.
After hearing me at length, everything has been mentioned in the order.
In the language, aspiring. Yes.
My lord, it's challenging the cognizance order, my lord. It's a premature stage, my lord.
Hey, that apart,
Public-
what about the notices? Notice has been served?
My
Notice
lord,
has gone?
Regarding notice, my
my
lord.
lord,
Have you
my-
read,
my lord,
read,
see
read the
noting.
order dated
My
8
lord,
to
see-
2024?
My lord, see the noting.
Noting. What
My
is-
lord, neither AD nor unserved notice returned from OP
You,
number 2.
you serve, let the opposite party be served through the IO. Despite, despite the service, opposite
Yes,
party
yes,
number
yes,
2
my lord.
has
Yes.
not appeared. The state council is, the IO of the case is directed to serve copy of the petition to opposite party number 2 within a week, lease the matter after 1 week, and interim order to continue. There is nothing in this matter, see.
Yes, yes,
There has to be.
yes, my lord. Just I'm.
I have actually passed the order.
Yes, my lord.
If you read that order,
Yes, ma'am.
you,
I will comply the.
yes. Only once his presence is there, then we will
Yes,
allow.
yes.
Yeah.
My lord, modification.
Item 92, may I please, my lords? An application for extension of time, my lords.
Extension of time.
My lords. The petitioner is a woman, my lords, and her mother died. He passed away recently in Ames
For the
Hospital.
reasons stated in the application, the
Earlier order was.
prayer for extension of time to surrender or appear before the court below is extended up till 30th September.
Obliged.
30th September 2024. The petitioner is directed to appear before the court on or before 30th September 2024 and seek appropriate remedy available to her under law. With this modification, the application is allowed. Yes.
Highly obliged.
Next.
93.
Wait, Your Lordship. Here, the last occasion, my lord was pleased to direct my learned friend to obtain instruction with regards to the CCTV footages.
My lord.
My simple prayer in the IA, which I have.
Preservation of CCTV footage.
My lord.
My lord, sorry to say, my lord, last sentence may be allowed to me. That has not.
So why I said is, see,
Only to
the
reserve, my lord.
idea of
Which in the, no,
Huh?
my lord, it's not required that, it's not required that, let me.
yes.
Here, my lord, it is not required that the IO should seize it and mention in the seizure list. My prayer is, if the CCTV footages will be preserved and it will be verified, the entire case of prosecution will go. Because I have stated so categorically.
What do you say?
My lord, he has challenged the cognizance.
That has
CCTV
been
footage
stated.
is not the part of the charge sheet. Now, my lord, senior submitting that there must have been CCTV footage that should be.
Now you tell me in the police station if the CCTVs are
That is
installed,
whether it was-
why for you have installed?
It can never be a part of this, part of the case.
Why for you have installed the CCTV?
CCTV footage, my lord, is not available. Because, my lord, now my lord senior is stating that it will be revealed from the CCTV footage. Whether it was preserved or not, that is also doubt. Because
That is what I am seeking instruction. If it is preserved, the idea of CCTV is only to know the fact.
My lord, that is for some period, my lord. The 6 months to 1 year, some.
That's what I am seeking in, I told you to whether it is there available or not. If it is not available, not available.
That is.
Where is the question of preserving? If it is available, you have to preserve it.
Yes. That instruction.
Shall I dispose it up saying that if it is available, it should be preserved?
Yes, as per the prayer, my lord. My lord, we see the prayer. I am very
Prayer where?
my lord.
Prayer of this petition.
Prayer of this case, my lord.
Yes. See, the idea of
At page
CCTV
6.
footage is leaving everything technicality and all. Why you are installing CCTV? To know what exactly has happened. If those evidences can be used for the purpose of reaching at the just decision of the case, why not? Why? That's the idea. Leave everything apart, whether it's a part of charge sheet, this or that. Procedure is leaving apart procedure. This is the idea. So preserve it if it is there. If it is not there, you can't help it. Where from you will get?
What now my lord senior saying that
He might be late. Yes, kindly pass the ruling.
Law is very clear in that aspect by the apex
Where is
clause.
the prayer?
Prayer melody is at page 6 of the bis case.
Yes, well, 6 and 16.
But 16 is the main prayer. He has challenged the cognizance.
6.
Oh, IA. My lord,
IA,
you should see that.
where is
Yes,
that?
IA. 1775 of 2024.
1775.
My lord.
Yes.
Lordship, I am for the informant. Lordship, I am instructed, but I am not sure that in CRLMC number 1376, the petitioner number 1 is no more.
Yes, he is no more. You have been instructed and I have received information 3 days back. He was present on the last
Petition
day.
number 2 is there. Huh?
Petition number 2 is there.
Yes. His father parent has died.
So
of the-
by this process, whatever CCTV footage would be there, that those things will be.
But
Where is the
petitioner-
prayer? 6.
Husband is there.
Father-in-law is no more.
Father-in-law is no more.
Yes.
Para 6, huh?
Prayer ballot. Prayer ballot may see. The
CCTV
petitioners
footage
pray that
recording
this
of all
honorable court
CCTV
may be
cameras
pleased to
and
consider the
cameras,
facts.
Devices of Napoli police station, including, and you preserve it.
Right.
If it is there.
Ballot.
I'll take instruction.
And how this CCTV footage will be utilized for the purpose of evidence, that will be seen at right.
My lord, one thing I just want to draw my friend's attention. They are avoiding it because my lord would see the affair. It is dated 12/12/2023. But in RTI, we have got what my lord the information is. This will.
I will not go into all this.
No, my lord, one thing.
I'll only direct
one
to
thing.
preserve
Why
it.
we are worried about that? My lord, we see.
Preserve it, that's all. What do
This shows 13/12. Affair at page 20 by let me see. In my brief. It's yes, it's yes. My lord print is very clear. 12/12. But this shows my lord 13/12. That is the for that reason, my lord, they say we had been to the police station. It's not there in the my lord CCTV, the footage in the police station.
According to you, CCTV footage is not there.
It's there. They have manipulated from the beginning. But one thing, another thing.
I don't want to go into all these things.
Yes.
And I'm not.
For that reason, I say entire case will go if the footage will be still.
Let us see.
FR 12/12/13. charge sheet
Although-
also it was submitted
okay.
also FR
12/12/12.
Okay.
But the police record says clear. Crime batch record says 13/12.
Although the petitioner has attained the order dated 25/1/2024, whereby JMFC 3 Bhubaneswar has taken cognizance.
That is also that is there.
Offenses.
That I have challenged and my lord was pleased to grant stay.
Offenses in city case number 1209 of 2023. But Mr. Dhal and senior counsel submits that he won't be pressing
No,
the
that is-
petition at this stage.
No, my lord. Cognizance I have challenged. That is stay. Cognizance order.
No. You what I am trying to say is will not interfere in the cognizance order. Allow your application, preserve it, and utilize it wherever.
No, cognizance order has been challenged in criminal discus number 1376. That is pending.
That's the main petition.
No, there are two petitions, Lordship.
Two separate.
Two separate petitions.
No, this petition, I am talking about this petition.
This petition is this case, my lord. This case only an IA.
No, 1376 also you have challenged the same thing.
No.
Cognizance.
1376 I have challenged the order taking cognizance. Yes.
And there's
And
another.
in that petition only you have moved an IA.
My lord.
I
want that is IA will be.
IA will be allowed
My lord.
and main petition will be dismissed. With the liberty
It has
to
not
you
been
to
hard,
raise
my lord.
all the, that is what I am doing. Otherwise, argue.
Yes, I am arguing, my lord. I am arguing, my lord.
I
How
will
the-
allow your application
With regards to
preservation. Then that is you can't move in a cognizance petition, challenging cognizance, you can't move
because
miscellaneous application,
when-
AG, whatever.
Because my lord, what?
That would be a substantive petition. I am allowing it that.
My lord, yes, my lord may dispose of this case, saying that I will draw the attention of the magistrate, and magistrate will entertain because
then
on the face of this case.
But that would be
My lord, let me.
better would be cognizance order. I will not interfere. The IA I will allow.
No, my lord.
And that will be preserved.
My lord, cognizance order itself, my lord, is illegal in the sense I will draw my lord's attention. My lord was pleased to.
If you are so confident about cognizance order will be passed, why are you asking for preservation then?
Preservation, my lord, that will go to the root of the case and my lord.
Then cognizance order goes, everything, the root and everything will be gone.
No, my lord.
What will you do with evidence?
On the facts also, I have to.
You are not sure about your cognizance order.
No, my lord. In the criminal case, my lord, what I have not till date,
say that the
what I
cognizance
have
order is
not
bad.
till date, I believe I convict, I disbelieve I acquit. Today, my lord, the case will be before X, it will be allowed. Tomorrow it will be.
That is a different.
That my lord, I have learned till after completing around 35 years of the profession.
That is a different story. But
My
what
lord.
I'll do is, I'll
My
not
lord, what I
interfere in
want
the
to say,
main
my
order.
lord, I am apprehensive of the fact that in criminal case number 1376 of 2024, while hearing for admission, my lord was pleased to grant stay, interim stay of the further proceeding. If I will file this application before the magistrate may not entertain the same, for which I have filed here. My lord may direct that.
You move application.
Yes, my lord may direct that I will move this interim application before the magistrate, and magistrate will pass an appropriate order.
Learned counsel for the petitioner. IA, that is 1775. Learned counsel for the petitioner has moved this application inter alia, making various prayer. He submits that in the main petition, since the trial court proceeding has been stayed, he has moved the present application before this court. Before this court. I am not inclined to entertain this application in the present proceeding. However, liberty is granted to the petitioner to make the said application before the make the same prayer before the trial court by moving appropriate application. If such application is moved, notwithstanding the fact that this court has stayed the entire proceeding. Have I stayed the entire proceeding?
Yes, madam.
Where is that? No, I have not.
Lordship, 779 you have stayed. Not for 1376, not for father-in-law.
That is also here.
Yeah.
Notwithstanding the fact
that
Only for the husband it has been stayed.
My lord was pleased to grant stay in the case of criminal case number 779 of
notwithstanding the fact that the this court has stayed the proceeding qua the co-accused
Her father-in-law and mother-in-law.
in CRLM 779 of 2024.
Yeah, Husband from case of stay. Don't mislead the court.
I'm not misleading the court. I'm saying the husband stays. What I'm saying not.
Shall we consider and dispose of? Release both the matters after 4 weeks. Interim order to continue. Yes. You move the application. I've said that notwithstanding the stay order, the application will be considered. Yes. 95. 95.
I have filed one in this case for correction of typographical error.
Where is that?
Both in my IA petition as well as in certified copy.
Which order?
My lord, order dated 3/9/2024.
3/9/2024. Correction 3/9.
Yes, my lord. In the last portion, paragraph
6/9.
6/9 voting is there 6. Item 95.
Item 95.
Powers were 96.
Oh, 96. Oh, sorry. Sorry, madam. I'm sorry, madam.
Yes. 95. Who is that?
This is also correction, my lord. 95.
Correction. What correction?
It was bail. It was what CRLMC was written in the order. Though it is a bail application, but in the inadvertently it was typed as CRLMC.
Yeah, anything can be done in our omit correction. Yeah, 6/9/2024 correction. ठीक है, allowed application. ये last लिखा है चीज liberty with this liberty CRLMC dispose of bail petition. Bail application dispose of. Yes. 96. Yes. What correction, sir? In
96, my lord.
Order dated.
Order dated 3/9/2024.
What are the corrections?
Correction is paragraph 8, GR case number 9. It should be 953. 953.
GR case 8/580.
853. It should be 9. My lord, it has occurred due to wrongly typed in my petition.
That's the problem. What can be done? You have to correct that petition. Not the order. Don't correct the order. Order is correct. Your petition is wrong.
Yes, madam.
You are asking correction of my order without
No,
correcting your petition.
I am praying for both correction of
You
my
first
petition.
correct your petition. Then
Yes, ma'am. Yes, madam.
What is this? It is causing.
Yes, madam.
Huh?
Yes. The subsequent successive
FIR
bail.
is same, FIR is same, FIR problem is not there.
No,
Different FIR,
different affair.
different FIR.
Different affair means the GR case number is same, FIR is same. Different affair I could not get, my lord, but
See, GR case, the same FIR you have filed or the entire FIR and everything is wrong?
no, only GR case is number is different.
Show me the petition. You people are filing so casually, what to do? GR
My
case
lord, I'm sorry, man.
953.
Yes,
953, that is correct.
Correct.
953, yes.
What is wrong then?
853 is wrong.
See, in the front page of your petition, you have written rightly.
Yes, ma'am.
953.
Yes, ma'am.
But in the body, you have written
Paragraph 4, 853 and
953 kar diyo GR case. Instead of what is that? Instead of
853.
853, 953 kar diyo. Yes, that's the correction. 950.
Para 8, no? Para 8.
No. In the two, in the front page, he has written rightly. First paragraph, he has written rightly. But in the prayer, he is wrongly. Yes.
Your lordship's order said that is para 8 also 853.
Wherever GR case is there.
I may be permitted to correct.
Yes, correct. And petition, let him correct. Yes. Next. 97. 97. Yes, sir.
This is the case under section 138 of NIA, Miller.
Yes.
Miller, I have.
You are the accused.
Yes, Miller. I have filed for cognizance of the complaint case, Miller. Passing of the cognizance of the complaint case, Miller.
Achha.
On the ground, sole ground, Miller. The company has issued the checks, but without making the company itself the party.
Yes.
Directors were only.
Yes. How do you defend your?
My lord, I rely on a decision, my lord. Yeah, my lord, one thing I want to say, they are builders, my lord. An agreement was executed. I
am not on the story.
Lord,
who has issued the check?
My lord, the company has issued the check.
Then without company, you can't prosecute.
Your lordship may see the cost title. Your lordship, for a moment, see the cost title.
Come to the complaint.
Page 13.
Yes, I am there. Page 9.
Page 9, Miller. Your lordship just turn to
Suresh
one
Chandra
Serial number 2.
Antarjami Badu
and Sri Muktikant Bodu.
Yes.
No company is made a party.
I'm submitting.
So, my humble
1 minute.
Yes, I'm submitting. Here, my lord, in the cost title, they allege that the company has not been made a party. In the entire complaint petition, it has been stated that the company is the accused and the company has issued the check and legal notice has been issued to the company. I, in support of my contention, my lord,
How much money taken?
90 lakhs and agreement was executed. 5 complainants are there to develop the land, my lord. In the meantime, they have been paying since 2015.
How much you have paid?
54 lakhs they have paid in the meantime. During pendency of the complaint case also pending before.
You had paid 90.
I am the one the complainant.
I understand. How much is recoverable from them?
Now 40 lakhs.
40 lakhs. Why are you not paying 40 lakhs?
Miller, I have already paid, Miller. I have already paid the amount. What they have done, Miller, they have taken the money and they have not delivering the possession till date, Miller, even though they have taken 90 lakhs.
And how many cases you have cheated people?
No, Miller.
He should have gone to economy wing.
Miller.
Because on 138 small technicality, you are trying to.
I go down to your lordship's view, but I understand that if they can proceed against me in other cases, Miller, in different forums. But so far as 138 NIT.
138, whatever. Why don't you pay the money? See, the poor people, they have hard-earned money, they have invested for their house. And you have taken the money, given the check, it is got decision. Why have you issued the check then?
Miller, I have already paid the amounts and they have not handed over the possession.
Why have you issued the check then?
Miller, at the time.
Why the company has issued check?
Company has issued checks, 90 lakhs paid, rest of the amount for the check was issued, check was dishonored. Thereafter, I have paid the amount. They have never handed over the possession to whom I have sold the property.
Well, let them show
The-
they have paid,
if-
my lord.
They,
54 lakhs.
If you have already paid, why have you issued check in their favor?
No, Miller. Earlier, I had paid. I had earlier issued the checks and some part of the money. I have already handed over. Thereafter,
How much exactly you owe them?
now 40 lakhs, Miller. 54 lakhs, Miller.
You pay the money. Forget about the technicality. I know this.
Let them, Miller, my humble submission, I have sold as power attorney holder, I have sold the properties to the vendors, Miller. Till date, possession has not been handed over. Possession is with them, Miller. Possession of the land.
You generally don't give possession also. I know that.
They have.
I know that you don't give possession. You show that is the land. And put a flag there and say that is your land.
Miller.
That kind of possession you give.
Miller, from
And
where?
you take money from all the innocent.
I have not taken, as your lordship understands, Miller, unless until I hand over the possession.
138 meter, but see, I can interpret it.
I bow down your lordship's view. Unless until I possess.
I don't know. You give back the money.
Milord, unless until the possession of the land is handed over to others. Let them.
I'll record. He'll give the possession. You pay the money.
Yes, Milord. Let them hand over the possession of the property.
Yes, you come with the money, and I'll ask them to hand over the possession. Pay back the money and finish it up. Finish it up.
I may be pardon, my lord. Okay. In this case, what happened? After I am paying the builder is paying the money regularly to them, but they are filing an amendment petition to other company as an accused.
I don't know because I know that
that is the sole difficulty we are facing.
With respect, I'll tell you, I have seen one of the complaint against your company by the couple of lawyers of this High Court. You have done the same thing with the lawyers of this court. So yes, I have came across. Therefore, I'm saying, you pay the money. You have done the same thing. You have taken the money, gave the check, and you have shown that that flag. You put a flag there. That is your land, and you have done it to the lawyer of this court.
No,
you may not having the instruction. I know that.
They
Therefore,
are the landlord. They have given us the property.
Okay, let us sort it out. You give the money, he will give the possession. I'll record it and sort it out your problem. You are the builder. You will take that land from him and sell it to someone else. You get the money. You pay back the money and
sell it out.
They have sold some portion of the land to a mining company.
I know all these things are sold. All this is a big problem in. You come with the money, part of the money, I'll give the position. I'll record it.
Yes, we have already paid him 54 lakhs.
Out of?
Out of 90 lakhs.
See, that's 40 lakhs you have.
Out of 59 lakhs we have paid. Out of 90 lakhs.
40 lakhs has also to be paid.
5 lakhs in your complaint petition you have admitted that 5 lakhs has already been paid.
Shall I send it to mediation? You will sort it out. That's it. I'm sending it to mediation. You sort it out. Right now. This present petition is arising out of a complaint under section 138 NI. There is a claim and counterclaim on behalf of both the parties, and since the dispute is arising out of the payment of the repayment of the money towards the consideration, sale consideration. Where the landowner has not allegedly not given the possession to the builder. Therefore, I am of the considered opinion that the matter could be settled through mediation. Therefore, the parties are relegated to the High Court Mediation Center. The parties shall appear before the mediation center on 17th of this month and explore the possibility of the settlement. And after the mediation, the mediation center shall place a mediation report, release the matter on 24.
Is
24.
that, interim order to continue?
Interim order to
And
continue.
Along with CRLMC 1421 of 2018.
At CRL, সেটা আমি লগে দিব সাথে
1421 of
1421. All the matters 17th you go and appear, and 24th I'll hear it and settle the dispute.
1421 of 2018.
Interim order will continue till then.
Okay.
You have also difficulty. You have not implemented the company.
That is where.
So better that instead of running around, you settle it.
And Supreme Court has made it clear, my lord, mere technicality will not over. I have the citation. The
You will
lordship
only the order, your lordship understand.
2020
Clearly
Supreme
made
Court.
the- unless until
You have difficulty. There are many judgment against you.
My lord, but this is the latest, my lord, I've got exactly quoting the same cause title in that case, my lord.
Anyway, now since you are going to mediation,
My lord.
don't argue on technicality. Settle the dispute unless it's required. Yes. I think you can settle it down. Yes.
99.
99.
Humbly pay my the lordship may reflect that they have paid that amount 54.
No, no, I am not saying anything. You settle it. If it doesn't happen, then I'll look into it. Yes.
Oh, bless.
99 should go to. Why?
Connected matter 753.
My lord, that application has been rejected by the coordinate bench on the ground of removing the defect. That was not disposed upon on merit.
That is a report. Registry might be saying it.
That was due to non-removal of defect, that application has been. Dismissal.
This is then it has to go to that court.
My lord, that application has. That
Same
was
petitioner,
that
same petitioner.
Same petition, but that was not disposed upon merit due to non-removal of defect by the petitioner. It has been raised.
Whatever. Judicial propriety demands it should go.
Your lordship had passed the order on
It was not
May
pointed out last
20th May.
It was not pointed out earlier. Now it is pointed out. Why should I?
If it was
The
disposed
earlier-
upon merit, then
Earlier, the present petitioner has approved this court by filing CRLMC number 753 of 2021. The coordinate bench of this court has dismissed the CRLMC by order dated 6/4/2022 for non-removal of the defects pointed out by the registry. The present petition, in the present petition, the same prayer is made. Since the coordinate bench has dealt with this matter, dealt with judicial propriety demand that the
other matter connected, no earlier application has been rejected or dealt with by coordinate bench. That may be taken up.
Which one?
Two matters is there. CRLMC 1012 of 21.
Before the bench, which has already dealt with the CRLMC.
GR case, it a DB case or connected.
With subject to permission of the honorable court. Yes, next.
Lord, 1012 also, it is not connected. It is
It's not
around to GR case.
1012.
Yes, ma'am.
It is not connected.
No.
Yes. This can be taken.
1021 is challenging the DB proceeding. In a similar application has been rejected by the for non-renewal by coordinate bench. But 1012 is pending since law.
Yes. What is
that can be taken up.
That is what is this?
Act is my lord. Petitioner is the husband and opposite party the wife.
Yes.
After resigning for 1 year, they have appeared before there are some disturbances between them. FIR, counter FIR, and they approach the Women Commission.
You are for opposite party.
I am for the OP number 1, wife.
And in the Women Commission, he has agreed for mutual divorce. And the Women Commission directed me to deposit 2 lakh something. I have deposited that amount, but on the date of deposit, she denied. So Women Commission has rejected not to interfere. There is a proceeding. That is a proceeding.
Yes.
After that, now the case is.
She has the right to withdraw consent anytime.
Yes, that is the. He has filed, after that, filed that DB case, present DB case. And in the meantime, my lord, diverse proceeding has already been going on. And from my side, evidence has already been closed. And she has to give the evidence. So within 2 to 3 months, my lord, that proceeding will be
over,
closed. Direction 5,000, 3,000, 8,000.
And that is a separate cause of action. DB is a separate cause of action. Here, the petitioner in this application has challenged the FIR and passing of the GR proceeding, where the police has already submitted the charge sheet and the matter is ready for hearing. He is not adducing summons has been issued also to the witnesses. This is arranged out of a GR proceeding. 1012.
12, this is regarding the FIR.
FIR, passing of FIR and GR proceeding.
No, you are getting confused.
Sita galani 102122 ta gala city.
The one which you have argued that has gone to some other court.
Connected hai kya chis seta GR requesting of.
Let it come next week, any date, your lordship fix it.
Urgent, this matter urgent. This is
Your lordship may fix it to next week. Because
1012. Urgent. Okay. Okay.
In
the meantime, charge sheet has been submitted.
This you might have confused.
1012, he is challenging.
No, why he got confused? You just see the number. 1021.
No, it is similar to
1012. Only one number here.
It is different. No? He is challenging the.
Let it come after one. 100. Urgent. 101.
100, my lord.
100 somebody asked for urgent.
My lord, without taking the consent, my lord.
I don't know. Many a time you do it. Many a time you also do it. What to do?
No, my lord. This is the important matter because the wife is the 120.
What to do? I have to believe this is so. In the morning time, and it's so much crowd. I can't keep on asking you. Somebody.
Then your lordship may any early date may be taken because the wife is, my lord, starving, my lord. Because my lord, the amount is, due is 8 lakhs.
Who is your friend who is mentioned without telling you?
Vishwaranjan Mahapatra, my lord.
You ask him.
So what date, my lord, it has been taken? What's it, September? Because this
what did you do today morning? What did you do? Item number 1, you started mentioning. Item number 1.
No, my lord.
You mentioned it or not?
No, I have mentioned for a withdrawal.
Why? Whatever. Item number 1, you started mentioning. You have no patience to wait till item number 1 is
no, my lord. Another item is 1 in the item number 3.
Whatever, the same thing might have happened.
I have to assist to my Mr. Senior, my lord, Mr. Shorting, my lord. So that's why I have mentioned. Otherwise,
no, I have to believe the lawyer who is mentioning what to do.
Because
yes. Let's see. Its hot date is given, so don't worry.
My lord. Because what happened? This pendency of this CLMC, now the execution proceeding has been stalled, my lord, in the court below.
But generally, I urgent it to December. Now you are lucky that it's. 103. Yes, sir.
Wait, please, your lords.
Yes.
One to Arjun.
103, huh?
Item number 1, my lord, there is a interim order that may continue.
Yes.
Lordship, item now 103, Lordship. Lordship, pray for 1 week time, Lordship.
You are for?
We are for the connecting CLMC number 1951 of 2023, Lordship.
In
first
that
item,
I am appearing for the informative, lordship. There is a stay order, perhaps there is stay is continuing in favor of.
Stage operating against them. They want adjournment what? On the request of opposite party number 2, let it be adjourned. Interim order is there. Continue.
Challenging the order of cognizance.
Whatever. The on behalf of opposite party number 2.
No, I am appearing for 2. My learned friend appearing petitioner short for time, lords.
Petitioner in which was
Sub-item.
Bipin Bihari.
Yes, sir. I am appearing for OP2.
Well, that case is what I have.
Absolutely
Absolutely, totally different matter.
That case might
But
be.
it is out of the same FIR.
No. I don't know who has mentioned it and how it
How
has
it
been
is got
tagged.
Lordship, absolutely different affairs and kindly separate from the item number 1, Your Lordship.
My case is different, but
How it is tagged then?
I don't know how order has been passed and how it has been tagged, my lord. I think in my absence.
Just check it up, huh? Retag kar do koi. This is
1951 is
in this. And the 85?
एक केस रही ऑर्डर नहीं नहीं की ऑर्डर कला केमती चार सबमिशन है somebody must have mentioned
Yeah, I don't know who has mentioned. Lease the matter on 10th July along with CRLMC number.
But on verification, verification of the records, nowhere nothing is there in no way connected.
Is it not connected? Otherwise, no. By the order dated 8/5/2023.
My lord can verify because when coordinate bench has passed the order, my lord may verify both the cases. No way connected.
I am going by your statement.
No, my lord,
Statement
just
of
verify. Otherwise, court has passed an order.
Somebody might have asked for getting completed the order.
So on mention, it has been done. I
Check
think.
it out. Okay. That is Arjuna. The one he is appearing. This the second matter. That is
Lordship,
one
in the first matter,
1951.
we are for the informant.
23 Arjuna. Yes, first one. 1140. Yes, what is this matter?
Ballot. May it please your Honor. Here on the basis of an information lost by my lord opposite party number 2, a case was registered under my lord Bhadrak Town Police Station head PS case number 18 of 2018 for offences punishable under sections 341, 342, 353, 294, 506 by 34 of the Indian Penal Code, my lord.
Yes.
The investigating officer thoroughly investigated into the case and submitted final form under Annexure 2 and 3, my lord. Final form and the order on 4/4/2019 in that respect, I have annexed as 2 and 3, Annexure 2 and 3. Notice was issued to the complainant. Complainant turned up and filed a case 1CC number 133 of 2019, where the Honorable Court, after completion of inquiry, was pleased to take cognizance of the offences punishable under sections 341 to 94, 506 by 34 of the Indian Penal Code.
Yes.
My lord.
Come to the prohibition allegation.
My lord. That is at Annexure 4, my lord, case 25.
Where is the
My lord.
there is no supporting affidavit also. Complaint. Where is the complaint?
Complaint petition is valid Annexure 25.
20?
Sorry, Annexure 4, page 25. Sorry.
No, I just see page 26. It is direct.
26 is the initial statement.
No, then 25 is the only annexure. It is half. It is not complete.
No, 25, 27 is there.
No, 25. Thereafter 26 is the initial statement.
26
25 is the
because
cost title.
they have obtained certified copy for which I have pasted it at 26. Or else it continuing on 27, 28, 29, 30, 31, and 32.
30 facts of the case.
32 is the prayer.
Initial statement is in between.
In between, the someone say would have certified copy.
Yes.
So after considering the complaint petition and the statements.
No, I am just therefore you come to the last page, prayer.
Well, under these facts and circumstances, it is prayed that kindly admit the case.
Where is the supporting affidavit?
It's not there.
Are you sure? Who is appearing? Where is the supporting affidavit to this complaint petition?
Clearly against Pala 2015 Supreme Court.
Priyanka.
Chopra. Srivastava.
Ah.
Chopra.
Priyanka.
2015 Supreme Court by
Yeah.
Honorable Justice Deepak Mishra.
Where is the supporting affidavit to this complaint?
Lordship, pray for 1 week after.
Misplaced for us, I'm sorry. It's been misplaced for us, my lords, and I have two files are there. Admittedly, the other matter that is tagged, my lords. We are the
See, the certificate copy is placed on
my
record.
lords.
And there is no supporting affidavit to this complaint.
My lords, it is the problem being, my lords, there are two briefs and both have been intermixed, and that being the thing, that is the reason.
Are you sure that along with this there is a supporting affidavit?
My lords, as I remember, it is there. I was appearing on the earlier date.
Then the entire thing goes. Entire thing goes if you don't have the affidavit. Show me the affidavit. I need not go into anything else.
Lordship, but take it up next week, my lords. I will.
Yes, do you have that affidavit? Are you
No.
sure that affidavit is there?
That is the
Or it's
last-
not there?
That is the last page, my lord. The head comparing clerk has signed on it as the last page.
That's right.
That cannot be
Therefore,
another.
therefore, I don't think that you.
It might just have been misplaced, my lords. Lordship may accommodate for 1 day, my lords. I'll produce it.
And counsel for the opposite party seeks to 1 week adjournment to ascertain as to whether along with the complaint there was any affidavit filed or not. If no such affidavit is filed along with the complaint copy, then as per the judgment of the Honorable Supreme Court in Priyanka Mathur, Priyanka Srivastava versus so and so, the complaint itself is vitiated. Therefore, no cognizance would have been taken on the basis of the said complaint. Leave the matter coming week. Only to that extent you tell me. If that affidavit is not there, then the entire proceeding goes.
18th.
18. Only limited to that.
Well.
Yes. Yes. Compromise. Two compromise matters are there.
106, 107.
106, 107. Parties are there.
104 may be taken up. Some of the day, my 120 is there.
Give a date.
376 ରେ cognizance order ଟା stay ହେଇ ପଡିଛି 1.5 ବର୍ଷ ହେଲାଣି।
I'm ready.
ଆଉ ମୁଁ କିଛି ଅଧିକା କହିବିନି।
I'm ready to argue. No, I have no objection.
376.
376 cognizance stay ହେଇକି 1.5 ବର୍ଷ ହେଲାଣି 1.5 ବର୍ଷ ହେଲାଣି।
The stay order is passed, this is bound to happen.
No, but no. It's not there like that. But it's a case where I'm squarely comes under the category of case registered with an ulterior motive for wreaking vengeance. That is one of the ground of AN 1992 Supreme Court 604 Vigilance case. This lady has
Malafide prosecution.
This lady has initiated earlier 7 proceedings, and almost all proceedings are 354, 376 against me.
Against you?
Against me, and all the cases have been ended in final report. And this is the 8th.
So why are you waiting for final report to be filed?
My lord?
7 cases you.
No. That is not the fact, my lord. After the 376 case, my lord.
See paragraph 7.
Also he is an accused in a 436 case also.
Yes, paragraph 7.
He may be, but how many cases you have initiated?
I have given chart, but let me see.
Chart is at 4.
Page 4, paragraph 7. That it is amply submitted that the informant has filed.
Yes, the chart is there.
Petition all which were found to be false. Same was returned to the police, stating filed false case, and in the case so and so. The informant has also filed 2 FIRs through her husband and through one Kala Silka, both of which were also found to be false cases. A summary.
Yes, sir. But I will submit, my lord.
You had filed these cases or not?
My lord, pertaining to this case, my lord, the material has to be seen. Whether a prima facie case is made out or not.
But see, it seems you have no job except filing cases.
No, my lord. They are
7 cases you have filed against one person.
They are in litigating terms, my lord. Also, during pendency of this CRLMC, my lord, the present petitioner and his fellow men, they have put fire to my
An old
house.
man of
And
70 years.
and
he
PS
has
case
not
number,
been spared.
and my lord, PS case number 173 was also,
I'll hear it.
yes.
I'll hear it.
Sir,
No,
sir.
no. Leave it.
70 in the year 2000, now
106.
106. 106 and 107.
Actually, you people are misusing the machinery to settle your own score. And you are keeping Mr. Ragada engaged for this 5 seconds.
ये भी क्या गरीब लोग होता actually.
Entry order to continue.
Entry model country. Yes.
106 arrangement one case, my lord. PS case.
106, sir.
And 107.
Yes.
There are two petitions, my lord.
What are the offenses?
The offense on
354 and all. Yes.
351 to 90.
What about 107?
107, my lord. Same case, FIR, another accused.
Another accused.
All of them are petitioned, my lord. 354.
Yes.
They are friends, my lord. They are subsequently the matter has been compromised.
354 only.
Copy number 2 has,
Compromised?
Yes. Compromise.
Appear.
You are appearing for?
I'm for the petitioner.
I am the OP number 2.
Okay. Who is Priyanka Naik?
Okay.
Oh, the girl.
Check it.
And Om Prakash? Om Prakash. And who is this?
Kanu Charapati.
Kanu Charan. Both the accused,
Yes.
same
One-
FR?
Same FR.
You just ask the girl.
Yes, sir. Yes.
What is the age of this girl? 21 years. Where is the affidavit?
Age 21.
Show me the-
Age 21.
21, no problem. Ask Om Prakash. And where is the girl's affidavit?
21 years.
Where is her affidavit? She has not given the affidavit.
They've had joint affidavit. Both of them signed.
Okay, ठीक है.
Joint affidavit, both of them signed.
Okay.
Paragraph 2 and 3.
Yes, that Priyanka asked her whether she. The support staff may, what to do now? Then. But it has already been uploaded. I don't know who might have taken it.
For modification. Because there is a typographical error. Instead of 482.
Upload है. Wait, today immediately you go and do it. Right. Go and do it.
I may be
small
part-
things, you will move application again, listed and.
I may be pardoned.
482 जगह है 430 नहीं है.
My lord.
Do it right now, huh? Yes.
My lord. Item 105.
Yes.
Whether it will come in this.
I think how many matters remain miscellaneous matter?
28.
28 matters.
28 matters are left.
Miscellaneous matter.
89 matters. Others are getting.
Others are the miscellaneous matter.
Will come tomorrow.
Will come
My lords, one mention, my lord,
Yes.
subject to your lordship's approval. Weekly list item 2. I have received the instruction regarding the well-being. He is no more, my lords.
Right, weekly list number 2.
My lords, I am appearing in the matter.
Huh?
Yes.
My lords,
Yes.
I am appearing in the matter. Item 128, I guess.
No,
No,
this is
wait.
item 2.
We're talking about 2. Right. Mr. Rijvil and counsel for the vigilance on the instruction of
Sorry, my lords.
instruction from
Instruction from, my lords, Inspector Vigilance Baripada. Date of death is 10/12/16.
Right, good. A bit.
My lords, one more request, my lords. Today's work has been postponed to tomorrow. My lords, I may be accommodated for tomorrow, my lords.
Yes, yes,
I may be
tomorrow.
accommodated. my lords.
Tomorrow,
Great.
Mr. Rijvi's matters, just tell me.
My lords, great.
Which one item? Tomorrow, this will go tomorrow. The matter which can't be taken up today will be rolled over.
Already 11 is there tomorrow.
Yeah, rolled over to tomorrow. See, what is happening is because of the pressure of bail petition.
Yes.
If 100 bail petition is released, then these matters are.
Sorry, more important because
Still, I'm trying to take up a couple of matters.
Occasion is approaching, so
that is
bail
it.
matters are 16, 17 matters are passed over. That's the 16, 17 matters passed over yesterday.
Before the vacation, bail matter, pressure of bail is
To
always.
be taken up. Simultaneously, some
Let
matters.
it be there, let it be there.
Small matters will be taken up.
Yes, yes, I'm taking up.
Small
Okay.
request,
Yes.
129.
129, yes.
129, that vigilance hearing matter. I have already prepared the paper book, supplied a copy of the paper book to my learned friend. One of my difficulties, I have only 4 to 5 months left to retire.
You are worried about your retirement. People are there in the jail. They are not
Custody, yes.
Three appeals.
Let it be there on the board.
Yes.
Whenever I get time, I
Yes.
call.
Yes, small matter, that's why I pray.
No, three appeals are there.
Appeals.
Arrangement is for one appeal.
Okay.
Appeals are there.
I am for other 2 appeals.
Yes.
Let it be there. I'll hear it immediately. Whenever I get opportunity, I'll hear.
Exactly, 5 to 10 minutes.
Huh?
Lordships, may I mention lordships?
Awesome.
ठीक
Oh, that. Thank you.
State of